The House Committee on Elections will come to order. The clerk will call the roll.
Chair Shaheen.
Here.
Vice Chair Busey.
Here.
Representative Isaac. Here. Representative Morales-Shaw. Representative Plesa. Here. Representative Raymond. Representative Swanson. Here. Representative Toth. Representative Terry Wilson.
Here.
A quorum is present. As a reminder, anyone present wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing room. If you require assistance in registering or testifying, please contact committee staff. Due to the number of witnesses who are registered and accommodate all who wish to testify, there will be a time limit of 3 minutes per witness during public testimony. Members, please remember to check out publicly available comments. These comments are left by the public on each agenda item in our hearings. Comments are open until the end of our hearing and are posted upon adjournment. With that, members will start hearing bills. Chair lays out House Bill 3709 and recognizes Representative Diallo to explain the bill.
Thank you, Mr. Chairman, Vice Chairman, members. House Bill 3709, the partial count bill. This is a bill that passed out of this committee unanimously. Last session, 137 votes, 0 nays in the House, and it stalled in the Senate. This bill fixes an audit process that we have in our elections. There's been a statewide bipartisan concern to improve the integrity and transparency of the post-election audit process. The existing law requires election officials to audit early voting results by selecting individual precincts at random. This is an antiquated procedure that is error-prone and both labor and time-intensive, significantly slowing the completion of the audit. HB 3709 will standardize the audit process regardless of how or when Texans cast their ballots, and applying existing audit procedures, not new ones, for election day to early voting. HB 3709 allows election officials to audit their voting results by voting location rather than individual precincts, resulting in a more accurate audit. Instead of a review of an individual precinct, the audit would instead look at the entire population that cast the ballot at a voting location. Furthermore, HB 3709 will enhance integrity, transparency, and the ability to prevent voter fraud. It's important to note that this bill does not create new auditing procedures. The bill applies the existing procedure for election day to early voting, thus ensuring the entire voting process uses a standard and consistent process. I reserve the right to close, and I'm happy to answer any questions.
Thank you, sir. Thank you, sir. Members, are there any questions? Thank you, sir. We'll recognize your right to close. With that, we'll start public testimony. The chair calls Andrew Eller with Election Integrity Committee and Secure Texas Elections Subcommittee of the State Republican Executive Committee and self. Hello, sir.
Hello.
I show you registered as Mr. Andrew Eller, and you are representing Election Integrity Committee and Secure Texas Elections Subcommittee of the State Republican Executive Committee and yourself, and you are here to testify for the bill.
Yes, that is correct.
Well, welcome, and you may proceed.
All right, thank you. Yes, we are for this bill. HB 3709 actually helps a lot with the auditing process. I think, as everybody knows, typically 3 boxes are chosen, and when you're in a countywide voting situation, that makes it very difficult when you choose 3 precincts, and those 3 precincts are spread out, of course, across the county because people vote in each of these countywide locations. So, for instance, in Bell County, we've had to basically open 42 boxes to read, and if it happens to be early voting, they're opening at least 7, sometimes 8 different boxes, and then each box is changed out every day, so now you multiply that times the number of early voting days. That's the number of boxes that have to be opened, and so basically every ballot in the county is touched before you actually come up with the ballots that you do have to audit. And that is a very labor-intensive process, takes a lot of time, and I believe this bill would correct, well, not necessarily correct, but actually improve on that and make it a little bit easier to just do it with the countywide vote centers and help that out. So, and it also, I believe, with posting, I believe this bill also requests that this is posted, the procedure be posted on the countywide website, the county website. Currently, it's not required to be posted on the website, and I think that's a good thing to do. I know in Bell County it's posted, but in some counties they don't actually post the notice of this partial manual count, and this would be very helpful to get that posted on the website so folks know when that is actually occurring, and especially candidates, and they can get their watchers there if they need to as well. So for those reasons, we are for this bill.
Thank you, sir. Members, any questions? Let the record show Ms. Morales-Shaw is present. Chair recognizes Ms. Swanson.
Yes, thank you, Mr. Chairman. So I have a few questions about exactly how your procedure works. So when you open these, however many it is, 42 boxes, do you take all the ballots out and run them through the counting machine, and then you just say, okay, it found 20 ballots from this one particular precinct? Or does somebody go through them by hand and go, oh, found another one, and they might miss some? Or just, how does that work?
That is how it's done, is by
No,
hand.
that was an either or. Like, so the
Yes.
second one?
Yes, it is.
People
It
are
is
doing
done by
this
hand.
number?
Yes, because you don't necessarily run them back through the machines. I have seen them run through the machines during a recount, but not during the partial manual recount. So the machine can sort it by precinct in a recount if there's a recount done. But if you're doing a partial manual count, they actually manually pull out all those, and that box could contain 1,000 ballots. And there may be 2 ballots in that box for a particular precinct. And they have to go through it until they find those 2 ballots. And you're assuming there's 2 ballots because that's based on what the results showed. Mm-hmm. Hopefully the machine didn't mess up and there were actually just 2 ballots in there. So, and I've been involved in processes where we've used the machine counts to look to see if the hand count actually match, and of course they do. So, but that's what it's done. It's a very labor-intensive process, and in Bell County, for instance, we've had to actually bring in extra workers to do this partial manual recount due to the additional work that it takes to find these in all these boxes from a countywide location. I can't imagine what would happen in Harris County.
Okay, so when do you go and pull them? Do you do it in front of the poll watchers that the parties send? Because I have heard complaints that someone paid for a recount, and I don't remember what county, so this isn't on you or anything, but that county had already gone through all the boxes and pulled all the ballots before they even, this wasn't Harris County, sorry, I forgot. I remember now which race it was, and it was a congressional race this last time, and so they were upset because all the ballots were already pulled, and they felt like that was wrong for those boxes to have been open. Had the seals broken, they're open, and they're all gathered, and then that took away some of what they got to observe. So does the law address that, or is that just sort of left up to the election officials? How's that work?
I honestly, I'm not sure how the law addresses that piece of it. I know the ones I've seen for these partial manual counts, the boxes are not opened until they're in front of the cameras and everybody's in place, and then the boxes are opened one at a time and gone through, and when I say one at a time, I mean they're done, there may be 20 groups in there, and each group is doing a box at a time. So
Okay, that seems like the way it should be. I'd be interested
yeah,
to
normally
know
that's how I've seen
what
it
the law
done.
says.
I have not seen the
Yeah, this was
elections
a
department do it.
recount from the primary, so,
Yeah.
and it was in Harris County. I'll have to find out if what they did was legal. Okay, thank you.
Yes, thank you.
Members, any other questions? Thank you, sir, very much for being here. Chair calls Daniel Hunt. Representing SREC Committee SD3 and himself. Is Daniel Hunt here? Chair calls Ken Moore, representing himself. Hello, sir. I show you registered as Ken Moore. You're here representing yourself, and you're here to testify for the bill.
That is correct.
All right, well, welcome. You may proceed.
Okay. Well, this bill, what I like about this bill is it addresses concerns people have about the voting machines changing votes. And it does so by allowing you to, for example, in countywide voting, you can just look at a voting center. If you do it by precincts, then that means you have to go through all the boxes of all the voting centers and dig them out and find all the ones for that one precinct. But the way this bill is written, it allows you, in the case of countywide voting, to just look at a polling place, dig out their stuff, and then compare that to the hand count. And completely sidestepping the whole question of whether or not the machines are reliable, it does help give assurance that if something is going wrong, you'll be able to catch it. And that's why I think it's a good bill.
Thank you, sir. Members, any questions? Thank you, sir, very much for being here. Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You're here representing yourself, and you're here to testify for the bill.
Yes, I am.
All right, well, welcome. You may proceed.
I really love this bill. I echo the comments of the first witness. I do have a couple of concerns. One is this A1 part where it says that the custodian shall select the precincts at random, but it doesn't specify what that randomness is or that there be a specific procedure for that. And my concern is that if we don't have a written process and the general custodian of election records could be accused of like rigging the choice of what that is. In Tarrant County, the last time we had to choose something at random, what we actually got was some 20-sided die from a local gaming shop and rolled them in the presence of representatives from both parties and under the cameras so that everyone was assured that was really a random choice. So there's language later in the bill that the next section, the Secretary of State shall select in accordance with rules adopted by the Secretary. I think that language should be included when we're talking about the general custodian, just so that we have documentation of how this process is supposed to work and what you're actually going to be doing. I think that will eliminate any possibility of, improper accusations saying you're rigging this or anything like that. So I think that if we include specific language like that, it will increase trust in how this process is working. My other concern is what about mail ballots? So the partial manual recount, it takes a lot of time. You have to go through all these boxes, but it includes mail ballots. So if we have, say, 40,000 mail ballots, and they're stored in different boxes because they are processed as they come in, the partial manual recount team still has to open all of those ballot boxes and pull by hand all of those ballots for the precincts that are chosen. And because early voting is not location-based, it's all together. I think that this needs some sort of provision for how you're going to handle the mail ballots. And if you're going to say, we have a countywide polling location rather than a precinct-based choice.
Thank you, ma'am, very much. Members, any questions? Thank you, ma'am, for being here. Chair calls Dr. Laura Presley, representing True Texas Elections. Hello, ma'am. I show you registered as Dr. Laura Presley with True Texas Elections, and you are here to testify against the bill.
Yes, sir, I am
All
here
right,
to
you may
testify
proceed.
against the bill. The problem with this bill is that if you look at the code that it's changing, 127.201A says, the reason you're doing this partial count is to ensure the accuracy of the tabulation of electronic voting system results. If you do what's proposed without changing a few other things, you cannot ensure the accuracy because you can't audit. There's no report right now that's official that the counties have to report for results by polling location. It doesn't exist in this moment. The counties report canvassed results. Those are the official results by precinct. That's why this law says you manually count by precinct. So you can do apples to apples comparison to ensure the accuracy of those results. Does that make sense? That's what the law was meant to do. If you change it to countywide box, it's easier to commit fraud. I'm in complete disagreement, and I respect Mr. Eller, and I'm in disagreement with him. You cannot apples to apples compare. Now, the Secretary of State could get up here and say, well, you've got results tapes. Those are not official results. You want to be able to compare the partial manual count to official results. So we've recommended modifications to the bill that they require that this be an official report generated by the system. Now you can compare apples to apples by precinct. In your handout is the certification requirements for these voting systems. And on the second page that I have in your handout, it's highlighted, and it says the systems are certified to do what I'm saying. So all we have to do is modify the bill to require the counties report it by county-wide location by precinct, so that we could audit precinct by precinct, apples to apples, to what the code says the people have to canvass to. Does this make sense? I'm here for any questions. We've offered the amendments to the author. This bill did die in the Senate because you can't do apples to apples comparison, and that's the intent of the partial count. I'm here if there's any questions.
Thank you, ma'am. Members, any questions?
And
Ms.
you have
Swanson?
the amended language that I've recommended.
Do you think that doing it the way you want to do would cause even more problems with taking away people's secret ballot?
Oh, no, I do not.
Because you'd be showing exactly how those two people voted who voted across the county, and you'd have the Matt Rinaldi problem again.
Well, Senator, Representative Swanson, I think that that's inherent to countywide. That's not inherent to the auditing process. Okay? I think countywide is a big hairball. It, by definition, violates the ballot secrecy, by definition. And if you're going to change the auditing so that we can't audit, this is not what we need to be doing. We do not need to be moving away from auditability. So personally, I would leave it the way that's why I'm against this bill. I would just leave it the way the law is, because you cannot audit now and do the intent of the partial manual count to compare to the precinct results. I'm sorry that it takes a while for these counties to go, pilfer through these ballot boxes, but that's the cost of doing countywide, where it's convenient for the voter and a little inconvenient for the election administrator, where they get paid to do this. Okay? So pick. Do you want convenience for the voter or convenience for the election administrator? If you want convenience for election administrator, go back to precinct voting for the audit for this. And you preserve ballot secrecy. I'm against this bill.
Thank you, ma'am. Members, any other questions? Thank you, ma'am, for being here.
Bless y'all.
Chair calls Terry Putnam, representing himself. Hello, sir. I show you registered as Terry Putnam. You're representing yourself, and you're here to testify for the bill.
The name is correct. I'm going to change my testimony to on the bill.
Okay. Just hold on 1 second with us while we change your record. So now I'm showing you registered as Terry Putnam. You're representing yourself, and you are neutral on the bill.
Yes.
All right. Well, thanks for being here. You may proceed, sir.
This is a very confusing bill to me, but I have several concerns that the bill doesn't seem to address, and I'm not sure it's addressed elsewhere in the code, but a manual count. That calls for a manual count. That's the existing law, I think. But a manual count of what? My understanding, and I may be wrong, is that they count ballot images, not the paper ballot. The ballot images are created by the machines. But to do an audit, you have to count the actual paper ballots that the people have submitted to the tabulator. The other thing that I am concerned about, one of the other people brought up, was the random picking of the ballots to be counted. That doesn't seem to be a public event. I would like to see how that randomized selection is done and have it done in a public manner. So that's my testimony. Thank you.
Thank you, sir, for being here. Members, any questions? Thank you, sir, for being here. Chair calls Laura Rogers with the County District Clerks Association and herself. Hello, ma'am.
Good morning.
Well, technically, it's 12:05.
Oh, good afternoon.
So I show you registered as Laura Rogers. You're here testifying on behalf of the County and District Clerks Association and yourself, and you are here testifying for the bill.
That is correct.
All right, well, welcome, and you may proceed.
Thank you. Like you said, I am Laura Rogers. I'm the County and District Clerk from Sherman County. I also conduct elections and do voter registration, so I consider myself somewhat seasoned in the election world. We are in favor of this bill. Not only would it improve the process that goes into the partial manual recounts, but it will prove the accuracy of the election. One thing that I want you to keep in mind is the fact that this is a partial manual recount. It's not a total recount. So really, you're just looking at a snippet of the election to ensure that the election equipment was accurate. Also, it is auditable. I am a precinct-based county. Your early voting tapes that come out whenever you're doing your end of the night reporting, those are official records, and they do show precinct by precinct results. And so that is a record that can be provided for audit purposes. So like I said, we're here in support of the bill, and I'll be happy to take any questions.
Thank you, ma'am. Members, any questions? Thank you so much for
Thank
being
you.
here. Chair calls Ed Johnson with Harris County Ballot Security and himself. Hello, sir. I show you registered as Ed Johnson. You're here representing Harris County Ballot Security and yourself, and you're here to testify for the bill.
That is correct.
All right, well, thanks for being here.
Moving the mic up some. Correct. So just to be clear again about this process and what you're trying to achieve, this is a limited recount, and it's part of actually the logic and accuracy test to make sure your machines are working correctly. And they're recounting the paper ballots that were voted. Currently, when the code was written, everybody was precinct voting, and you would just take a precinct and count it. Now that you have countywide voting and 60% of the people early voting, because early voting comes into this too, you don't have everybody voting in one precinct. So you now have to go through every ballot in Harris County. You know, you're talking 1.5 million ballots you're going through to find this one precinct. It's paper ballots, which takes weeks to do. And then you have a recount. But when you just recounted this, you're recounting a precinct, but these people voted on a whole variety of different election equipment. It isn't just one piece. By doing it by polling location, you're auditing that poll to make sure the equipment in that polling location comes up with the right count. And the election office has it by precinct, but they also have all those memory cards that turned in by polling location too. So they have the number of votes cast in a polling location. So this is better, a really true audit of the system if you want to really check the machines, to do it by a polling location where you can compare it to the memory cards and the paper count to make sure everything was correct. When you do it by precinct, you're not auditing the equipment. You're getting a wide variety of equipment from across the county. So this is the only way to really truly do a audit on the equipment, and saves tons of time to do it this way.
Thank you, sir. Members, any questions?
Yes.
Ms. Swanson?
Thank you, Mr. Chairman. Okay, I wanted to ask you a few questions about that other people have brought up. Do we need to add a report for polling locations for people to be able to audit later? This information that's found out, do we need to put that out and say this many people voted for so-and-so at this location and that location?
I don't believe so. Well, you know, you as candidates like the precinct report at the end, so you see how you did in your district in different precincts, how many votes you got. That's the information you're looking at. I don't think you really care where they went and voted on that day. You're just looking at how did the voters in my district vote, so I would know how my campaign went. So
I actually do like to get that information, and we can't get it anymore because I need to know, like, where should I go stand, this polling place or that one? Where are my voters going? So, but once they got worried about the secret ballot thing, we can't get that anymore. So, okay, what about how to spell out the three precincts you pick? Is there nothing in the law that says how to pick those
I believe
three?
that comes from the Secretary of State's office. It's a random, they generate it randomly. So I would assume that the Secretary of State's office would randomly pick the polling location that you're going to do.
So maybe we need to ask them. And then, okay, somebody brought up the question, do they count ballots? It sounds like you and some others indicated that. Or do they count images?
Every time I've seen it done, it's been ballots.
They go dig that piece of paper out.
They go dig that piece of paper out.
Okay, all right. And how would, somebody else brought up, how would we audit the ballots by mail?
I would, ballot by mail would still be done by precinct. This just is for countywide polling locations, this bill, and early voting locations. So,
Just to check how those machines work, so therefore you don't need to count
But, you know,
the mail
ballot by
ballots.
mail all comes into one
Right.
PO box in the office, and they'll just have to sort those out by a precinct to audit that precinct's ballot by mail.
Okay, that all makes sense. I would like to ask the Secretary of State if they picked the three precincts or whether something needs to be added in there.
Members, any other questions?
Thank you.
Chair calls Christina Atkins with the Secretary of State's office. Ma'am, I show you registered as Christina Atkins with the Texas Secretary of State's office, and you are neutral on the bill.
Yes, sir, that's correct.
Thank you. Okay, so tell us how the three precincts get picked now, and then under the bill, how would the three polling locations get picked? Do you really send out the instructions, or you expect them to figure it out and flip a coin out in their particular counties?
Great question, ma'am. So for the elections in which we're required to select the precincts or polling places used for the partial manual count, we actually have a software application that we use, or we do some other forms of random selection, rolling a dice, drawing names, numbers out of a hat, something to that effect, so that it's a randomized selection. It's not based on, any other additional knowledge outside the fact that it's a location or precinct used in that election.
And you said the elections that you're required to choose them, is
Yes,
that
ma'am.
most all of them, or?
It's all of our larger elections in which the general election for state and county officers, our primary elections, if we've got a constitutional amendment election, so where we have statewide offices or statewide issues on the ballot. For example, our small local elections, our cities and school districts, if it's not conducted at the same time that one of these larger elections is happening, then they actually make that selection locally.
Okay.
And the law says that they have to make a random selection, but it doesn't define what those methods of random selection are.
Okay, so now tell us about, if we pass this bill, how will the three polling locations get picked?
Largely the same way that we're doing it now. The law as it's written, it's not referring to voter registration precinct, it says election precincts. And election precincts is referring to election day locations. And so for countywide polling places, for election day already, we have given them the alternative. We select some locations and we give them the alternative, since the statutory language allows it to be by location on election day. We will say these are your selected precincts, voter registration precincts for your mail ballots and for early voting,
on election day, you can use these alternative locations since the law supports that. However, the law doesn't support right now doing it by location for early voting. And that's where I think a lot of the testimony thus far has addressed that issue.
Okay.
That counties are having to sort through, in our large counties, thousands and thousands of ballots to find those selected precincts.
Okay, but no matter what, the Secretary of State's office is going to be picking the precincts or now the polling locations unless it's a smaller
ma'am.
election.
That's
Okay,
correct. Yes,
all
ma'am.
right, thank you.
Members, any other questions?
Chairman,
Oh, Ms. Morales-Shaw?
thank you. You just clarified, I think, because we heard testimony earlier that there was a concern about early voting and how it's mailed into the PO box and you have to shift through those, but you're saying that's not the case?
For early voting by mail, those are currently done by your voter registration precinct. We select those 3 precincts, and then for those mail ballots, there really is no other way to do it other than sorting through and finding those specific precincts, and then doing a hand count to see if that matches the tabulated count.
Would this bill affect mail-in ballots and early voting?
It affects early voting in person, the much larger number. It does not specifically change anything with respect to early voting by mail, so that'll be conducted the same way that it has been.
Got it. Thank you for the clarification.
Yes, ma'am.
Thank you, ma'am. Members, any other questions?
Yes,
Ms. Swanson?
thank you.
Sure.
Okay, so it sounds like everybody counts pieces of paper that they dug out of boxes under the current method, and they don't count images like one witness was concerned about. Is
Yes,
that
ma'am.
right?
That's correct. They are counting the physical piece of paper. That's the ballot of record in the election, the official ballot, and that's what they're
Right.
counting.
Right, okay. Now, what about what one witness brought up, that if we do it by polling location, then each county needs to be putting out a report by polling location so that audits can be done by the public?
So I think there's kind of 2 points I would bring up on that. First, the text of the law doesn't require that we're comparing this to the official canvassed returns. It's just verifying the accuracy of the tabulating equipment, which in a polling location is going to be that precinct scanner. That's what's tabulating your results in that location. And so there is a report generated from that device in that location that provides that vote breakdown. And so you have that printed report from the actual device itself at the location for which these ballots were counted that you can compare your hand count to. And then I think beyond that, we do have one vendor now that currently can produce a report by location, and we have been working with our other vendor to work towards that, to make some of the necessary modifications so future versions of their system can also produce reports by location. So
Which
that there's
vendor can do it now?
Hart InterCivic.
Okay. And would that be required that each county would make that public?
So I would say any report generated in an election like that, any kind of results report, those are election records, and the default is that those reports are available to the public as already, and have been produced many times by counties that generate these reports by polling location.
So would that interfere then with this whole problem that people who vote on the other side of town have their, they can figure out how they voted?
So with respect to that issue, ma'am, I think, again, right now, all of these different reports and precinct level reporting, which is what I think some of our other witnesses referenced, that's all already available to the public. So those reports that break down vote totals by precinct, already public. No matter what method of voting is used, countywide precinct-based, mail ballot voting, I think even provisional voters, anytime you have a small number of voters in that category, that's where we run into the problem of potential ballot secrecy issues. And just to give you an example, in Dallas County, in the primary election last year, there were, I think it was 20 voters that voted in the Democratic Party, where they were the only voter in their precinct that voted in that primary.
Sure.
So if that precinct had been selected under current law for the partial manual count, they would have had to count that one ballot. And so it would have, in putting out their
Right.
partial manual count results, could have potentially revealed how that voter voted.
But in the past, I'd get my consultant to figure out not necessarily how each of my people voted, but I want to know where do they go. And so she couldn't get that this time. And we understood it to be because of this whole secrecy thing, and that your office had told the counties like don't give this out and this out and this out. So is that why we couldn't get hold of that information?
Yes, ma'am. It's because we did issue some emergency guidance with respect to this issue, and what we did is educate counties on what the law says with respect to redactions under the Public Information Act. We told them, in light of this ballot secrecy issue, here are a number of data points that you may want to look at that, if revealed, could result in revealing how an individual votes. And then there is a process by which they can seek a ruling from the Attorney General's office. So they're not just redacting on their own. They're coming up with the potential redactions and then seeking permission from the Attorney General's office to allow those redactions. And so it was educating them about the data points they should look at and about the process that's available to them, so that when they get requests, they can make sure that they're considering an individual's right to a secret ballot. So it was about redacting data.
I'm still not sure, am I going to be able to get those results by polling location next time?
I think it depends on the specific reports and data that you're looking at, and it depends on usually how many people voted in that election, kind of the larger context. If we want to talk a little bit more specifically, maybe about looking at a specific election that you know, in the data requests that you asked, I'd be happy to sit down with you to figure out what request you made and perhaps why they were telling you no to certain requests.
Because this does figure into this whole thing that one of our witnesses brought up. She wants a report done by location. Okay, they're going to audit this stuff, give us reports by location, and yet we couldn't get this stuff this last time, and you said it was because you told them they could redact stuff. So how's it going to be from here on out?
That's a great question, ma'am. I think, anytime you release information about where an individual voter votes, that's where we run that risk of bumping up against ballot privacy and an individual's right to a secret vote. But the reports that we're talking about are about, it's not going to have names of voters, it's going to have vote totals. So when they're generating a report, when you print a tape from a voting device at an early voting location, it's going to give you the total votes per candidate that were cast at that location.
And I should have still been able to get that this last time?
Yes,
Because that's all I want.
Yes, ma'am. That information does
That really
not...
busy place over there really only has 3 of my voters, so, I shouldn't go stand there. So that's what I'm looking for, and we couldn't seem to get it this last time.
Well, maybe I can come by and visit with you on that,
Okay,
and
but you
we
think
can...
they'll still be making this report that
Yes.
our witness asked for, and they'll be able to get it?
The precinct by precinct report,
That's
as it
not what
exists...
she wanted. She wants location by location report, so she can compare and audit.
Oh, I understand now what you're asking, ma'am. A location by location, further broken down by precinct within that location.
I think that's what she's asking for. She's nodding back there, yes.
So I think that's where, that's kind of the essence of what we need to look at with respect to this ballot privacy issue, because if you're able to identify an individual voter by looking at that report, because it's the only voter that voted at that location, and you know that voter checked in at that location, that's where we might have some privacy issues.
But you think you fixed that legally by the stuff you told them to redact, or? Because I don't think we ever changed anything in the law to fix that, because we weren't real sure how to do that.
And I think, the guidance that we issued, again, was emergency guidance to deal with that, and that's because we had no other options at that time. I think there have been a number of lawmakers that have asked questions with respect to this issue, and it is probably something that's worth some discussion from a legislative perspective, so that we're not relying on these redactions as a fix, and that we're kind of fixing the bigger issues.
But none of our bills do that?
I would say that we'd have to look and see if some of the other bills that are filed address some of those issues,
Okay.
and be happy to look at that. I'm
Okay.
not sure that we've had any, that we've
Not
discussed
so
this
far.
in the committee so far.
Okay, all right, thank you.
Members, any other questions? Let the record show Mr. Raymond is present. Mr. Raymond.
Thank you, Chairman. So I just want to make sure, so if I lose and we have a recount, will this make sure that I win? Is that the right bill, or is that a different bill? I'm sorry.
Yeah. Members, any other questions? Thank you, ma'am, very much for being here. Is there anyone else who wishes to testify on for or against HB 3709?
Mr. Chairman?
What?
Mr. Chairman,
Okay, let's get a little focused here. Is there anyone else who wishes to testify on for or against HB 3709?
Mr. Chairman?
Yes.
Can we recall Ms. Cano, because I want to hear
Sure.
her response to Presley.
Sure. Chair calls Catherine Cano, representing herself. Ma'am, I show you registered as Ms. Cano. You're representing yourself, and you're here testifying for the bill.
Yes.
Okay, you may proceed. I think Ms. Morales-Shaw has a question for you.
Well, I just saw you nodding your head back there, so I wanted to hear, and obviously, one was for and one was against, so I'd like to hear your reconciliation of that.
I think that what Ms. Presley was requesting is already addressed in the official tapes that come out of the polling location when you close the polls. But if it's not, I'm sure that our vendors would be happy to work with us to create a report that would do that, because they've always been very responsive. Currently, Tarrant County uses HART. When we get the closed polls report for early voting and for Election Day, it includes and it's an official report because we're not allowed to provide it to the public until close of polls on election night. It has a breakdown of all the votes that were cast per candidate. I believe the tally system that we use with HART can produce a breakdown by location already. We just don't usually provide that because people are more interested in the precinct report. So I think that information is actually available or can be easily made available.
Are you speaking to the audit part of her testimony?
Yes, that's what
Okay.
you would use for an audit. So if you're wanting to look at a location and you want to compare the results for a specific location against the machine results, so you would take the ballots for a location, you would do your count on those, the manual count, and then you would compare that to the actual tape of the results that are produced. And if you are concerned about whether or not that tape was accurate, you have the drives that contain the actual cast ballot records that are assigned to each location. And the counties they should be. They keep track of what drives, what machines are issued to each location. So you can go back and review lots of data that way.
Got it. Okay, thank you for that clarification.
Members, any other questions? Thank you, ma'am, for coming back up. Is there anyone else who wishes to testify on for or against House Bill 3709? If not, the chair recognizes Representative Diallo to close on the bill.
Thank you, Mr. Chairman, and the witnesses for this discussion about this bill. That's kind of how these bills, these unintended consequences that some people are concerned with, and you have the testimony, lively testimony like this, it really makes a difference. I think most of the concerns are addressed in the bill, and elsewhere I will still work with the stakeholders to make sure that we got every I dotted and T crossed. And with that, I close.
Thank you, sir. Members, any questions for a representative? Thank you, sir.
Thank you.
If there is no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 766 and recognizes Representative Cortez to explain the bill. The chair offers a committee substitute.
Thank you, Mr. Chairman. Members of this very attractive committee. This is impressive. This is most impressive. I'm a little intimidated, to be honest with you, Chairman, but I'm going to go ahead and lay out this bill. Thank you for the opportunity to lay out House Bill 766. The committee substitute for House Bill 766 would require persons applying to become precinct chairs to include an email address, phone number, or both on their applications. In the 2020 to 2022 election cycle, the Bexar County Democratic Party received 444 filed applications for precinct chairs, and nearly 20% of them had no contact information aside from a mailing address. With this change, local authorities and parties will improve their ability to contact applicants quickly and efficiently rather than relying solely on a mailing address, which costs extra time and money compared to a correspondence via email or a phone call. The committee substitute makes clear that the contact information the applicant provides is confidential and not public information. Look forward to working with you, Chairman, and members of this attractive committee to hopefully see this bill through. And I respectfully reserve my right to close, sir.
All right, thank you. Members, any questions? Mr. Raymond?
Chairman, thank you. Thank you, Chairman, for bringing this. This is,
Thank you,
we
Chairman.
had that issue too in Webb County and it probably all over the state. It's an important fix, and I just want to thank you for bringing it forward.
Thank you, Chairman. Appreciate that.
Members, any other questions? Thank you, sir. Chair calls Ed Johnson with Harris County Ballot Security and Self. Hello, sir. I show you registered as Ed Johnson, and you are here testifying on behalf of Harris County Ballot Security and yourself, and you are here to testify against the bill.
That is correct.
Okay, you may proceed.
I have one for you. So this bill would make it, I guess, more restrictive for a precinct chairman to file for office than any other statewide candidate, or any other state candidate, or any county candidate on the ballot. Your application that y'all filled out allows you to put in your email of your campaign and a phone number of your campaign, and those are both optional. So now we're going to make a precinct chairman required to give their personal email and their personal phone number on an application that can be obtained by an open record request. It is available to the public. My wife's a precinct chairman. She told me she does not want her phone number available to have people just go from open record request and harassing calls. And that happened to her in several elections back, where they got the information from the election department, and she received harassing phone calls all up leading to the election. So I don't know why we would want to make this harder on a precinct chairman or put them more vulnerable to be harassed with their personal information. That's what you're requiring them to do. I personally think that precinct chairmen are part of the party organization, and if the party wants this information, they can make a party rule saying that they have to provide that information to a party to apply for a precinct chairman, but don't put it on an application that anybody could go out and make an open record request and get a copy of it. I know a lot of precinct chairmen that don't want their personal phone number out on the internet everywhere saying that.
Mr. Johnson, would you be willing to work with the bill author? Because the intent is for the precinct chair to be treated like any other elected official. So whatever all of us are required to put on the application, it would be the same for the precinct chair. Because I think a precinct chair is elected if there's a challenge. So would you be willing to work with the author? Because I know that the intent is to make it the same.
Yeah. Currently, the intent that is the same currently. So this bill would make it different from what y'all would have to fill out.
I had to fill out my email and phone number, I think.
Yeah, it's your campaign. It says your campaign email or phone number, and both of them are optional on the form.
Yeah, so I think if you work with the bill author, I think you'll come to agreement, and you might have a little bit more in common.
Unless y'all want to provide your personal phone numbers and emails.
My personal cell phone's on there.
Oh, it's good to know. Make an open record request.
I'll just give it to you. Ms. Plessa?
Yeah, thank you, Chairman. So, Mr. Johnson, I'm just a little confused because I'm actually reading the bill. Have you read the bill?
Yes, I did.
Where in the bill does it say it has to be their personal
It says one that they can be contacted
email
at.
or personal cell phone number?
It says one that they can be contacted at.
So it can be a Google number.
If they can get contacted at the Google number, I would assume so.
So it can be go to GoDaddy.com and buy a website, and put that there. It could be that. So it doesn't-
Emails are real easy. You can go get an email from anywhere. It's the phone number that's more the problem.
But it doesn't say in the bill specifically that it has to be their personal email. What it says is, and I'm going to read it. It says, an application for a place on the ballot as a candidate for precinct chair must, in addition to complying with section 141.031, right, includes an email address at which the candidate receives correspondence. And it actually says here relating to the candidate's campaign. So the way I read that and understand that is actually not their personal. The way I'm reading that is a campaign email. The second section, or the second part, says a telephone number at which the candidate can be reached, Google number, seems appropriate here as well. Still not personal. And then 3, an email address and a telephone number described by subdivisions 1 and 2.
So a lot of precinct chairmen don't have a campaign email or a campaign phone number. I mean, these are volunteers that are doing this, and if they're following this code, it's a phone number that they can be reached at, which, you know, would have to be a personal phone number.
Okay, then I have
It would
another
make it very
question for you.
difficult on them.
If someone's running for an elected office, do you not think that the constituents that are going to be served by that representative, whether they're state representative or a precinct chair, should have some kind of identifiable information so that they can call that individual, whether to say, I want to volunteer, or I don't appreciate you running for this position, or whatever. So is that your stance, that constituents shouldn't have access to information about their electeds?
No, so in a precinct chair race, it's a small little race here that we're talking about, and it is done by the parties. I think this needs to be in the party rules that you obtain this information. And if you're a part of that party, you could get the information from the party, not open to the public. You know, when you list your stuff, do you want everybody calling you, telling you don't want to run?
I'm like the chairman here. I guess I messed up. I put my personal cell phone number on there. So, you know, I didn't know, you know, that was an issue. I thought that we wanted our constituents to have contact with us. Anyways, thank you so much.
Members, any other questions? No. Thank you, sir, for
Thank
being
you.
here. Is there anyone else who wishes to testify on, for, or against House Bill 766 and its committee substitute? Yes, ma'am. Do you want to come forward and register? Ma'am, I show you registered as Ms. Catherine Cano. You're representing yourself, and you are here to testify for the bill.
Yes.
Okay, you may proceed.
So I'm a precinct chair. My personal phone number and an email address are listed on my party's website so that my constituents can contact me. I do agree it is a concern to have personal information out there where people can potentially harass you. So that is why when I first became a precinct chair, I had a Google Voice number that redirected to my personal cell phone. And I created a Google account, email account that was specifically for that precinct in my county. And if I resign as precinct chair, I will pass that email address on to the person who succeeds me so they can have access to all the history of emails. There are concerns about privacy, but I think they can be adequately addressed, and so I am for this bill.
Thank you, ma'am. Members, any questions? Thank you for coming forward. Is there anyone else who wishes to testify on, for, or against House Bill 766 and its committee substitute? If not, the chair recognizes Representative Cortez to close on the bill.
Thank you, Mr. Chairman. Once again, attractive members of this committee, I appreciate the opportunity to lay this out. Look forward to working with you on this bill. I won't stop you, Chairman, if you want to vote it out today. It's good legislation, I get it.
Appreciate that.
It's hard to hold it back, but I mean, I understand. If you need to do it today, it's fine. If not, I thank you for the opportunity, and I do close.
Okay. Thank you, sir. Members, any questions? The committee substitute is withdrawn. If there is no objection, the bill will be left pending. Is there objection? Chair hears none. The bill is left pending. Chair lays out House Bill 3775 and recognizes Representative Paul to explain the bill, and the chair offers a committee substitute.
Thank you, Mr. Chairman. Members, it's good to be with you here this afternoon. I won't give you the BS about a beautiful committee, but it is a great bill. This bill was brought to me by a friend of mine, and she had provided evidence displaying election officials processing ballots 3 days before they were permitted to do so. Current statute mandates that carrier envelopes cannot be opened or processed until polls open on Election Day or after polls close after a period for a person in voting counties larger than 100,000. This bill provides clear rules for the early voting ballot board dictating when or permitting to begin opening carrier envelopes or accepting voters. Gives a stage process for the different counties. If you're real small, you could start it earlier. There's a middle section between 100,000 and a million, and then what to do if you're over a million. So I think our expert witness will be able to give you a lot more details than I, but I'll be glad to answer any questions as you go through it.
Thank you, Mr. Paul. Mr. Raymond?
Chairman, just to comment that this is definitely one that we could vote out today. Like, no further witnesses needed, necessary. Show me voting aye.
Chairman, I believe you. I'm with you.
We have a few witnesses that are registered. Members, any other questions?
They're probably just going to hurt the bill, so I would just like just vote it.
All right. Members, if there's no other
Reserve the right
questions,
to close.
we recognize your right to close. We will proceed to testimony. Chair calls Andrew Eller with Election Integrity Committee and Secure Texas Elections Subcommittee of the State Republican Executive Committee, and yourself. You know, acronyms, Mr. Andrew, are really helpful sometimes. So
I guess we'll have to come up with some.
So I show you, sir, registered as Andrew Eller, and you are representing Election Integrity Committee and Secure Texas Elections Subcommittee of the State Republican Executive Committee, and yourself, and you are here to testify for the bill.
Yes, that is correct.
Okay, you may
And so we are for this bill. The only question we had on the bill is it does mention the leaving the ballot in the envelope, and is that referring to the secrecy envelope or to the carrier envelope? Either way, it doesn't matter to us, but I'd like that to be clarified probably somewhere along the line. The only thing we can see that that this would hurt is it would take a little bit more time in the central count area to open all the envelopes and lay out the ballots and get them flattened, especially mail ballots, because a lot of times it's very hard to get those through the machines due to the folding. And so sometimes it takes a little bit of time. You have to flatten them out and get them flattened. So I would suggest maybe a little bit earlier, and I believe I heard Representative Paul talking about maybe a third tier where the larger counties maybe can have a little bit more time to open those from the secrecy envelopes and get those flattened out before we actually start counting over the weekend before Election Day. But yeah, as far as keeping them in the envelopes, that's a great idea. That way people can't see these. I actually witnessed where the ballot boards were actually opening the carrier envelopes after they okayed the ballot, said that was a good voter, and then opening the secrecy envelopes right after they opened the carrier envelopes. And that does not provide secrecy to the voter. So it's a good idea to keep these in those envelopes if they can. So for those reasons, we're for the bill.
Okay. Mr. Raymond.
Thank you, Chairman. My first experience, one of my very first experiences in working in an election, we had a number of ballots that made the difference in the outcome of the election, and they had been opened well in advance of the election day, and it was the only thing that they were in were the carrier or the gray ones, right? I guess they're still gray. I don't know. When you mail it in, you put it in one envelope, you put that in a bigger one, you sign that. Anyway, and I challenged it. I was 19. I challenged it, and it was just flat stolen. The election was, in my view, just stolen because you didn't have the carrier. You didn't even have the carrier envelopes, for those. So it was terrible. So I'm glad you're doing this. Again, I think security is the most important thing, right? And so I think what we're trying to do here is getting us closer to that.
Yes.
Members, any other questions? Thank you, sir, very much. Chair calls Veronica Worms with the Texas Civil Rights Project. Hello, ma'am. I show you registered as Veronica Worms, and you're here representing the Texas Civil Rights Project, and you are here to testify against the bill.
Yes, sir.
All right, well, welcome. You may proceed.
Thank you so much. Our main concern with this bill is that would hamper the county's ability to contact a voter who submitted a mail-in ballot with a defect until the ballots could actually be counted. Under the election code, county elections offices can reach out to a voter and send them a corrective action form to cure a defect with the mail-in ballot or the carrier envelope. And ballots can be cured until the 6th day after Election Day. If the county can't even open the envelope to see whether there is a defect with the voter's mail-in ballot, then it gives the county less time to let the voter know about the defect, and as a result, less time for the voter to cure their mail-in ballot. A county should be able to let a voter know as soon as possible whether there is any issue with their ballot or the envelope, so that they can actually exercise their right to vote. This is especially important for our voters with disabilities and elderly voters who may need assistance and more time to get the resources together to cure their ballot. Overall, this measure will just make it harder for voters to use their legal right to cure any problems with their mail-in ballots and successfully vote in our elections. So for that reason, we ask you not to vote this bill favorably.
Thank you, Mayor, for being here. Members, any questions? Thank you, ma'am, very much.
Thanks.
Chair calls Kathy Hagler, representing herself. Hello, ma'am. I show you registered as Kathy Hagler, and you're here representing yourself, and you're here to testify for the bill.
Yes, Mr. Chairman, that's correct.
All right, well, welcome. You may proceed.
Thank you. First of all, I would like to say that this would not affect corrective action in any way. I have testified to y'all before that I've worked with several different election integrity organizations statewide. I'm not speaking on their behalf, but it's because I've worked for them that I have this experience. I have developed several different times. I've developed training for ballot boards and central count based specifically on the SOS handbook for early voting ballot boards. I've provided you each a copy from the current handbook that explains the ballot board's current disposition of an accepted ballot, starting on page 17, section E. Step 1 has the board opening the ballot carrier envelope to remove the secrecy envelope containing the ballot. You go to the next page. Number 2 says you remove the secrecy envelope from the ballot carrier envelope. Now, in the SOS training, they're very specific to say the secrecy envelope, but in the law, it says ballot envelope. Are you finding it, Chairman? Okay. And then number 7 says that the ballots are transmitted to the presiding judge of the central counting station in a locked or sealed box. At no time does it say in that training that the early voting ballot board is supposed to be opening the secrecy envelopes. So now I'm going to give you 3 sections of election code because you can get confused easily. The first section is in 87.042, where it says the ballot board is supposed to place the ballot envelope or secrecy envelope containing the voted ballot into a container. Now, we're going to probably hear testimony today that some county is going to say that's not the way we always do it. We know that. That's why we're trying to ask for this bill so that it's more clear for everyone. And I wouldn't be surprised if someone testifies that their ballot board removes the ballots from the ballot secrecy envelopes before they're sent to central counting. Again, we know. That's why we're trying to clarify it with the bill. We're trying to follow the law. So if time permits, I would like to give you a little demonstration, but I'm going to wait to do that at the end if I have time. The second section of law is 87.062 that says the ballot board is supposed to remove the ballots from the secrecy envelopes, but you'll note that's only if you're manually counting the ballots. That is under subchapter D, processing manually counted ballots. So the early voting ballot board should not remove ballots from secrecy envelopes unless they're hand counting the ballots. The third section explains what you do when you are accepting a ballot that's going to go to the central counting station. And on the third section of that page, it talks about you deliver that container to the central counting station. So the photo on the back of the page were photos I took in November of 2024 of a county that was opening ballots 7 days before Election Day last November, 7 days. And your packet shows the last source from the SOS's Central Counting Station Handbook that says in counties less than 100,000, they can't begin counting until polls open on Election Day. Counties over 100,000, not and as soon as early voting ends on Friday night, the 4th day before Election Day.
Thank you, ma'am.
My time has expired.
Members, any questions? Thank you, ma'am, for being
Yes,
here.
I do have.
Ms.
yes,
Swanson?
sir. I'm curious, can you I just wanted to hear the rest of what you had, and the demonstration thing, like, really helps me if I can see how this works. And, because I know about working polls, and I know about some of these other things on the mail ballots, but central count's always been kind of a mystery to me. And anyway, I also want to find out, like, how would we open that many mail ballots in a big county like Harris County?
Okay. And you'll see some of those numbers at the end of my testimony that I wrote out for you. But in Harris County, they had 63,000 ballot by mails in November of 2024. In 2022, they had 100,000 ballot by mails. So if you start just going by November's numbers, if you put that out, they're doing over 1,900 ballots an hour. For working 8-hour days. So they just simply don't have enough time on the calendar or your watch to do it. So what I really think would be a great committee sub is if we would leave that under 100,000 election day at 7 a.m., that's perfect. But let's make another tier in there, make it from 100,000 to 1 million, just like it's always been after early voting ends. But then after 7 a.m. on the 6th day before the election, so on a Tuesday election, that would be a Wednesday morning, they could go ahead and start opening in the larger counties over 1 million. And I did talk to Ms. Hudspeth in Harris County, which is, of course, the largest county, and she said that would work for them. So I figure if it'll work for Harris County, it can work for everybody. So does that answer your question about that?
Yes, now I really want to see the demonstration.
Okay, so here's my demo.
I'm good. I'm big on
This is from
demonstrations.
an old form, because we don't have access to these forms. So it's an old form, and it
Okay.
says sample all over it. But when you're in the ballot board, you get things in a jacket envelope. And it's going to have information about the voter on it. So when we open it up, we pull it out, and we're looking usually at two things. One is the returned carrier ballot envelope, and the other is that, that application we talked about last week with the really tiny print. So we're going to look, and we're going to make sure that it has the information that's required, those numbers that are required, signatures. We're going to compare signatures. If you're on the ballot board, you're actually going to verify the reason they voted by mail. Once you accept that voter, okay, so I'm going to put the application back into this jacket envelope because the EA needs that information. But we're going to open the ballot carrier envelope. I'm just going to unfold mine because I don't want to mess it up. Once you get inside that, there's a ballot envelope. That's the secrecy envelope, but you see the law actually officially calls it just a ballot envelope, but it is a secrecy envelope. Inside of that envelope is where your ballot is. This is it's gummed, so it can actually be sealed. And so all that we're saying is that while the ballot board has this information that has this voter's name on it, that they never see what's inside this envelope, which has the ballot in it. You've accepted it before you even got this far. And once you get this far, all of those go together. And the law says you have to have 10, 15 or something before you can start counting any of those, but that would be in central count where they need to open those and count those. So it's very important that whatever we're doing, we make sure that you never have these two things in your hand at the same time. If this is open and you can see in a ballot, you never want to look in there. There's two times where you might actually have to look in there. It's if a statement of residence is required, and that'll be marked out here on the outside of the jacket. This voter was required to return a statement of residence or an ID. It'd be stamped across the envelope. And so when we opened up this envelope, we would hope that the voter included it outside the secrecy envelope. And we open it up and we just pull it out, we verify it's there, we're good to go if they live in the same county on their form. So now that we have these two things, we're good to go. But if it's not in this ballot carrier envelope, now we actually have to go inside the secrecy envelope, because if they didn't return their statement of residence form, they're going to have to be rejected. So we will look inside the secrecy envelope, we'll look in there, and my term for it is we treat it like it's a dirty diaper. We don't look at this. We're just looking for the statement of residence or the proof of ID. And there's rules about any time you've opened this before it goes to central count, it has to be taped. The presiding judge has to sign it and date it and say why it was opened, so that when they get it in central count, they'll know that none of these were ever opened unless it was to look for an SOR or ID. So hopefully that helps you to understand a little bit better why it's so important that we have one group accepting and a whole different group that's opening the ballots, and they have no idea where they came from.
That was very helpful. Thank you so much.
Thank you, ma'am. Members, any other questions? Thank you, ma'am.
Thank you.
Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You're representing yourself, and you're here to testify against the bill.
That is correct.
Okay, you may proceed.
Okay, so my concern is that this bill, the way it's currently worded, is going to break our elections, and that is not hyperbole. The timeline is much, much too short. So currently, we start processing ballots as soon as we have ballots to process. That's what the law allows the ballot board to do. The timeline's a little bit shorter if you're on a signature verification committee. If this bill were in effect right now with the May election, there are 4 days between the end of early voting and election day. That is not enough time for any team to process the number of ballots we're expecting to have, even like without substantially increasing the number of members. So normally we work on ballots for 2 to 3 weeks. I really like Kathy's demonstration. That was amazing. Although not every county uses the jacket envelope system, because if you have that information electronically, you can provide the application electronically, so you never are actually handling it. This is going to make it really, really hard for ballot boards to conduct their work. And I think there may be some confusion in language between central counting and central scanning. Central scanning is currently where ballots are processed by the early voting ballot board to be counted at the central counting station. And it's preparing the ballots to be counted on an electronic counting system, because we have paper ballots. We want to count them with the tally system, which uses the V drives from the Hart InterCivic thing. So we scan those ballots. They're not counted by the ballot board. They're counted by the central counting station. But we prepare them to be counted, and that takes a lot of time. There were concerns that this might interfere with the ability to take corrective action. The reason I really love Kathy's demonstration is because she mentioned exactly what I have here, SORs and IDs. The specific language in this bill would prohibit us from opening those ballot envelopes to check for SOR or ID documentation, which we do require in order to accept a ballot. So if we can't accept the ballot and then check inside the ballot envelope, like it's a circular loop there's no resolution to. I also am not fond of this language that would introduce empty ballot envelopes to protect what we call naked ballots, which are ballots returned without a ballot secrecy envelope. I don't like introducing new materials to an election that were not returned to us by the voter. There's also some language in here that says envelopes, but it doesn't specify carrier or ballot secrecy envelopes. Is it both? Is it one specifically? There are already some processes that we use in Tarrant County that allow us to keep track of how many accepted carrier envelopes and also how many ballot secrecy envelopes we have. I would be happy to work with the author of the bill to provide that documentation. But the way that this bill is currently worded, I'm concerned for large counties especially, it's just going to make it impossible to conduct an election at all.
Thank you, ma'am. Members, any questions? Thank you, ma'am, for coming up. Chair calls Terry Putnam, representing himself.
Mr. Chairman, I decline to testify at this time.
Okay. Hold on just one sec. We'll update your... Chair calls Ed Johnson with Harris County Ballot Security, and yourself. Hello, sir. I show you registered as Ed Johnson, representing Harris County Ballot Security and yourself, and you're here to testify for the bill.
That is correct.
All right. Welcome back. You may proceed.
Really good bill here. I will tell you, the previous witness talked about a different method than what Mrs. Hagler showed, and this is how Harris County does it. I actually was the, creator of this software. Large counties actually image all of these ballot. They image the application, they image the return ballot envelope, and then they stick all of these ballots in a container that gets locked and sealed and goes into a vault. And then the ballot board does nothing but look at electronic images to approve whether or not all the information is there. so they're not handling the ballots. And that was one of the reasons why in Harris County we implemented this, because it leads for less temptation the fewer hands that you have circulating these ballots around the office. So it actually comes in the mail, gets scanned, and then gets locked in the vault right after that. And this bill leads into that really good of those ballots should stay in the vault until it's time to start separating them and counting them. The one thing in the bill is we do need that tier for the 1 million. When you have 100,000 ballot by mails that came in 2018 when I was working there last, it takes more than 3 days to work to open 100,000 letters, unfortunately. But it's still all the same process, same secure. It's just you need more time with the large volume you're going to have in large counties to do this. But this would tail into that imaging system to where the ensuring that the ballot is staying locked and sealed and no one's tampering with it.
Thank you, sir. Members, any questions? Ms. Swanson?
So do you feel like the proposed time that Ms. Hagler gave would be sufficient?
Yes.
And she did indicate that she had cleared that with the Harris County clerk. Tanisha Hudspeth, and that she was okay with that time then?
Yes,
Okay.
that's about the time, when I was there in 2018, that's about the time that we had. And unfortunately, I think statute of limitations have run out by now. But yes, we were breaking the law because the law says it's 3 days before, but there was no way we could get that done in 3 days. So we
did not hear that.
We
Didn't
started
hear
5 days before to do it.
Any other questions, members? Ms. Morales-Shaw?
My mic isn't cooperating. There we go. It's my understanding that we were opening ballots in Harris County a month before Election Day, so they'd have enough time to count them, process them, and do everything. I mean, Harris County's huge. Would you agree with that, or was it a different time frame?
No, I would not agree with that. So the process goes to the ballot board, and the ballot board doesn't start meeting until 2 weeks, usually 2 or 3 weeks before the election. So, and they are not opening, like I said, in Harris County. It's all imaged, and those ballots are actually sealed away in a locked room. So they're just working with images, except for the one case off where you have to find that statement of residence. They may have to go find that ballot to open it to see if it's in the secrecy envelope or not. But the vast majority of them stay sealed during the process. But the ballot board is the one that starts this whole process.
So statutorily, we can only open them right now 2 weeks prior?
No, 2 weeks prior, the ballot board is not opening them.
Okay.
They're just approving that it's all the information is correct in there, that the signatures match on the application to the ballot, that the driver's license number was on there. If there was assistance, that the assistant signed it, and all the other information's there. So that's all the ballot board is doing, and then they're going to eject or approve this ballot, and
Okay.
we go into these tubs where all these are numbered, and you pull out all the ones that are approved and start opening them. Now, unfortunately, in Harris County, too bad he's not here. He would get a kick out of this. We actually had the first stage they go to is they go to the ironing department, because they've been folded up in this little envelope and they run through the scanner. So we have a whole section of ironing boards where we iron these all flat again to run them through the scanner. So it does take some time to do this, open them and get them ready to run through the scanner.
But you don't steam them, right?
No, we don't steam them.
Okay. So I'm
A little
still...
starch here and there every once in a while.
I'm still a little unclear. So statutorily, and I know they're not actually opening the ballots, it's the images, right? So how much time, what's the most amount of time that they can review those images prior to?
I think it's 3 weeks before the election.
3 weeks?
Yes. Yeah, you may have asked Secretary of State. My memory's a little slippy there, but.
Okay. And I was under the impression that Harris County, from my notes here, needed all of that time because it was such a massive amount to count. And you're saying that they can do it in less time and that Tanisha Hudspeth has agreed to that?
Yes.
Okay, thank you.
So they start reviewing them 3 weeks out, but only about 5 days out do they actually start opening these secrecy envelopes and separating the ballot out to put it through the scanner. And they're not actually counted, they just scan them and they record that onto a memory stick. And then until election night that they actually read that memory card to see what the votes were.
Thank you. That was what I needed to clarify. Thank you.
Ms. Swanson?
I also need some clarification, because, okay, they open, thinking about the demonstration here. So they open it and they take out this page that's like the application for the ballot. It's not the secret ballot, not the secret envelope. They're taking out some page that they had to sign. Is that correct?
Correct.
Now, is that what's scanned and they start?
Yeah,
Okay.
they scan all that information and then.
And that's what they're working on for 2 weeks or a month or whatever?
Yes.
Because I think that maybe mistakenly, you might have said the ballots. They're not looking at the ballots.
No, if
They're
I said
looking
that,
at
I
that
made a mistake.
page that's in there separate from the secret envelope.
Yes, correct.
Okay, so they take the secret envelope with the ballot that has not been opened unless they needed to hunt for a statement of residence or something else, the second thing, right? There were two things they're looking for?
Usually it's just a statement of
Okay.
residence. And
Okay, so, and they're not supposed to look. They do it in front of each other and don't look. Okay, so at that point, those secret envelopes with the ballot in them are put in this vault. So what they're looking at is not ballots that are imaged. It is, what do you call these pages?
Well, so you have the application and you have the carrier envelope that the
Okay.
ballot came in.
Okay,
And
so
any- and the
no
document.
ballots are looked at
No.
till what time right now? And if the bill passes, when would they be looked
Well,
at?
so right now, current law is you're supposed to wait till the end of early voting to start opening those secrecy envelopes.
Okay.
And that's usually done by teams of 3, where they open the envelope and one person makes a stack of the envelope over here and the other one puts the ballot over here. And then it gets passed to another person that starts ironing them flat, and then it goes to the scanner. But that way it's going to different teams, so no one ever can associate what envelope that ballot came out of.
Okay, so currently they can't do that till the end of early voting. So they start it at
Correct.
the end of the day on Friday.
So Harris County wouldn't be able to get it done if they started then, so they usually start about 5 days out.
Which is not currently legal?
Which is not currently legal.
Okay, but we won't talk about that then. So in the new bill, then what would be different?
Well, the new bill is requiring you to do the system that basically Harris County's doing, where you're keeping all these secrecy envelopes and the envelopes that came in a sealed container until 3 days before the election or
So
election night.
mostly the bill clarifies so that these other counties won't be doing it wrong.
Correct.
Okay, but then we need to have a slight tweak in it to make it where we give a little bit longer to the big counties.
Correct, because
Okay.
just because of the volume.
Okay, I think I understand now. Thank you.
Members, any other questions? Thank you, sir, for coming
Thank you very
up.
much.
Is there anyone else who wishes to testify on, for, or against House Bill 3775 and its committee substitute? If not, the chair recognizes Representative Paul to close on the bill.
Thank you, Mr. Chairman. Members, it's good to be here, and I think that we got a great piece of legislation here to take care of the problem that we know people were violating it by opening these ballots before. Let's make sure we get a process that makes it all legal, that we can get it done and done properly.
Thank you, Representative. Members, any questions? Thank you, sir. The committee substitute is withdrawn. If there is no objection, the bill will be left pending. Is there objection? Chair hears none. The bill is left pending. Chair lays out House Bill 4275 and recognizes Representative Paul to explain the bill.
Thank you, Mr. Chairman and members. This bill is brought to me another friend of mine who revealed unfair practices relating to the allocation of countywide polling locations. Under current statute, each county commissioner is guaranteed one countywide polling location, but their total number of polling locations can be nearly twice as many as any other county commissioner. Take Harris County, which had 800 polling locations and 4 commissioners. Hypothetically, statute permits one Harris County commissioner to potentially have 158 more polling locations than another commissioner. HB 4275 addresses this issue by providing for a hybrid solution for countywide voting. This bill will mandate each county election precinct to have at least one designated polling location. We are working on a committee substitute, make sure you're clear. We're not saying this is precinct-only voting. We're saying to make sure that it's going to be equal. I can tell you in my district, there was far less polling locations in other districts that were doing it. And so we wanted to make sure that each of our House districts are going to be evenly distributed. And by doing this, it's going to make sure that there are going to be equal number of combined precincts to make sure that we can do it. It'll still be countywide voting. That's it, kind of in a nutshell, but we got some experts here to talk to you about it.
Thank you, sir. Members, any questions? Ms. Swanson?
Thank you, Mr. Chairman. I just wanted to say this is a great bill, and this has been basically so unfair and been a nightmare in Harris County. And I've had that same problem, that I don't have anywhere close to the same number of polling locations that they do in other certain areas. And it seems to go along with the party that's deciding all that, and we need something in law to make that fair.
Yeah, I think, and hopefully this will make it work, because all it is voter suppression in our areas.
Exactly. Thank you.
Members, any other questions?
It is.
Yeah, I do.
Ms. Morales-Shaw?
Thank you, Chairman. So why do countywide locations need to be affected to accomplish what you need to accomplish? Which is to have more single voting
It won't change countywide
locations.
voting. There's still countywide voting. These are countywide voting locations.
Right, I get that, but why does that have to be addressed in your bill? If it's not affecting countywide voting, you're just saying we need more voting locations, right?
Yeah, because people are going to go vote. So during early voting, and especially election day, you go to vote. Most of them are going to voting in close by their neighborhoods or our voting locations in there. People out in our areas are going to have to wait tremendous more time in line to vote than if you're voting in other areas, which could be much more convenient and easier for those people to vote. In our areas, it's blocked, struggled, and hard to vote.
Is that because there's less polls?
Yes.
And what does our areas mean?
Our areas is my House district.
Is that rural? Is that a certain part of Texas?
It's part of Harris County.
Oh, it's part of Harris County, okay.
Yeah.
Well, don't the Commissioners Court, aren't they the ones who decide where the voting locations are going to be at before an election?
Ultimately.
Okay, and so, I see. So you're saying they're not putting enough locations where, in your part of town?
That's correct.
Okay.
Yeah, that's correct. So this is going to make sure that it's going to be fair and easy for everybody to vote and make it, the county's resources are all being spent in one part, not on the other. We want to make sure it's even. We just want the people to vote.
Right. Does your bill have anything about it being within voting polls being within a certain distance of each other?
No distance.
Okay, nothing about distance, because it seems like that would help if you said in a certain populated area there have to be this many polls within a certain distance.
By making sure that it's even by these precincts and how they're good, that should kind of make that distance work out, because those are blocks set up by population in there, so it should work out that way.
Okay. Thank you for the...
Members, any other questions? Thank you, sir.
And I wanted to say we are working on a committee substitute that will help out with the fiscal note to make sure that works out. So we're still continuing to work with stakeholders.
And you want to reserve your right to close?
Reserve the right to close. Thank you, Mr. Chairman.
You bet. If there's no further questions, we will proceed to public testimony. Chair calls Veronica Worms with the Texas Civil Rights Project. Hello, ma'am. We show you registered as Veronica Worms, and you are representing the Texas Civil Rights Project, and you are here to testify against the bill.
Yes.
Okay, well, you may proceed.
Thank you so much. This bill requires a countywide polling county to have a polling place in every election precinct in that county. This essentially negates the benefits of countywide polling. It allows counties to establish the most convenient polling locations for their voters while cutting costs of mandated polling locations in a specific area. The LBB clearly shares this concern as the bill has a $4.7 million fiscal note. All this bill seems to do is take local control away from counties and their communities who are in the best position to establish the polling place distribution that makes the most sense for them, while costing taxpayers more money. Countywide polling has been growing in popularity in our more rural and sparsely populated counties because it offers the county the flexibility to establish polling places that best serve their voters instead of just blindly following the precinct map. When there are finite election funds to go around, it makes sense to allocate our polling places in a way that best serves our communities, instead of mandating distribution that may not best serve voters. For these reasons, we ask you not to report HB 4275 favorably. Thank you.
Thank you, ma'am, for being here. Members, any questions? Thank you, ma'am, for being here. Chair calls Lucilia Siri, representing herself. Hello, ma'am. I show you registered as Lucilia Siri. You're representing yourself, and you are here to testify against the bill?
Yeah, Lucila Seri, yes.
Okay.
Actually, I don't know, I'm going more of a neutral now because I agree that this kind of defeats the whole purpose of countywide voting.
I just wanted to make sure, were you changing your position on the bill? I wanted to make sure I understood.
Yes, I'm neutral now.
Are you neutral now?
Yes.
Okay, give us 1 second. We'll update your
Good.
registration, and then
Good.
you can stay right there. Now I show you registered as Lucilia Siri. You're representing yourself, and you're now neutral on the bill?
Yes.
Okay.
Because maybe by me talking, some clarifications
Sure.
will be done.
Okay.
Yeah, because my first point is, I kind of agree with the lady before. This kind of defeats countywide voting. One of the reasons why we do countywide is the cost. That is, like, I'm from Tarrant County. We have 694 voting precincts. Countywide requires us to have half of them. That is 347. And still, I think that I don't agree with the locations of them, but I think that this bill could be done another way, being more, hey, you need to be more equal. In Tarrant, we have a problem because we have some precincts that we have 50% more polling places than on the other count of the other party. Maybe the bill should say that you need to be more equal in the representations between the county commissioners' precincts. Also, my concern is that if this passes and we need to allocate all the county in every single precinct, means that Tarrant County needs 694 e-poll books. And that is a lot of money and a lot more electronic equipment. So if we're going to be doing this bill, maybe put that we do paper ballots or something like that. So just saying, I don't think that the bill as written make much sense. I do think that we need to go back to the whiteboard, and I think we can do better than this.
Okay, thank you, ma'am. Members, any questions? Thank you so much for coming and testifying.
Thank you.
Chair calls Ken Moore, representing himself. Hello, sir. I show you registered as Ken Moore. You're representing yourself, and you are neutral on the bill.
I am neutral on the bill, yes.
All right. Well, you may proceed.
Now, I'm placing myself neutral because there's some concerns, all right? Generally speaking, I like the bill. The fly in the soup could be that the way the laws are currently written, that this thing has to interact with. In Harris County, it would require, well, in any large county, it would require that have a polling place in every precinct. In Harris County's case, that's like 1,151 precincts, and that's a lot of equipment, and the concerns that have been raised so far are very valid. There is, however, a bill on the Senate side that would change the language and fix this. And if I could just make a plug for it, y'all to consider. It's SB 985 by Betancourt. If that bill passes, then this bill is a wonderful bill because then it allows the polling places to combine, like they've done in many cases already. If that bill does not pass, then this is a terrible bill because it forces every precinct to have polling place in it. So with that caveat, yes, I like the bill, but those are my concerns and simple solutions.
Thank you for coming forward, sir. Members, any questions?
Yes.
Ms. Morales-Shaw?
Thank you, Mr. Moore. Are you saying that SB 985 is reverting us back to each precinct having a poll?
No, but it would change the language to allow to combine precincts. When I was in Harris County, and this was back during the days of precinct voting, we routinely would combine, precincts. I think the largest combination I had one time was a light election. I had like 17 precincts meeting in my polling place. The way the law is right now, you can't do that. Okay?
Got ya.
And 95 would fix that so you can do it. And that combined with keeping the distribution more even, I think makes it a great bill if 95 passes.
Okay, thank you.
Members, any other questions? Thank you, sir, for coming up. Chair calls Catherine Cano, representing herself. Ma'am, I show you registered as Catherine Cano. You're representing herself, and you're here to testify against the bill.
Yes.
All right, well, welcome. You may proceed.
Okay, so the reason I do not like this bill is because it does keep countywide polling options, which I think are great. I love that. But it would kind of push us back into county election precincts, which, as we heard earlier, are not necessarily the voting precinct locations, but they do allow a certain amount of combination. Currently in Tarrant County, with vote centers and countywide polling, we have 347 locations. That is difficult for us to get at. If this bill passes without the SB bill that was just mentioned, which I believe is equivalent to HB 342 that was heard by this committee by Representative Hayes, that would allow additional combination that would reduce the number of polling locations that we had to have, but it still might push us to a max or a minimum limit that is difficult to achieve. If this bill currently, as it's written, passes, we would need 430 locations in Tarrant County. I think it's actually 433. We do not have the locations. Locations don't want to have us. They don't want the difficulty. They don't want the risk that's associated with it. To have even an election day polling location, you have to have a location that is compliant with all the requirements that you need. It has to have adequate parking. It has to be ADA compliant. It has to have the space that you need. They also have to allow you several days before and after to put equipment in that location, to have it secured so it can't be tampered with by, people in the building, and then allow time after the election to have it picked up. We don't have the staff. It's hard for us to get election judges and clerks as it is, and we don't have the equipment. We barely managed to make our primary work with 400 locations, and if we have to go above 400 locations, we're going to have to spend a lot of money on equipment. We're going to have to spend money on equipment, staff, and locations, and that's not a cost to the state. That's a cost to every individual county. So my preference for this would be to maybe make this optional. Like if counties have the ability to have county election precinct voting, okay. But if they don't, give them the option to keep the current countywide voting vote centers as they are. So that would be in subsection A. Maybe just add an and an or. So yeah.
Thank you, ma'am. Members, any questions? Thank you so much for coming up. Chair recognizes Kevin Hale with the Libertarian Party of Texas and self.
Could you please change that to neutral?
Yes, hold on one second. We'll
Thank
change your
you.
registration. Sir, I currently show you as registered as Kevin Hale, and you're representing the Libertarian Party of Texas and self, and you're currently registered for the bill, and you want us to change that to neutral?
That is
Okay,
correct.
hold on one second. Okay, I'm now showing you as Kevin Hale with the Libertarian Party of Texas and yourself, and you're now neutral on the bill.
That is correct,
All right,
sir.
you may proceed. Thank you, sir.
Thank you, Chairman. I would like to make this real simple. I will ditto Ken Moore, and I will ditto Cato Cat. So thank you very much.
We love dittos. Chair recognizes Travis Ransom. Welcome, Judge. We show you registered as Travis Ransom. You are representing Cass County Judges and Commissioners Association?
Yes, sir.
And you're here to testify against the bill?
Yes, sir.
Okay,
That's
well,
correct.
welcome, sir. Thanks for being here.
Thank you. Thank you for having me. So it depends on what your definition of precinct is. As the representative laid out, precinct as a county commissioner's precinct, well, of course, every county has 4 county commissioners' precincts, but each county is different in their amount of voting precincts. So if we're talking about voting precincts, Cass County has 18 voting precincts. We typically have 11 polling locations. We recently went to countywide voting, and we've had 4 elections using countywide voting, and it's been very successful. Our constituents love it. We're a huge rural county, 936 square miles. In the northeast corner of Texas, Arkansas-Louisiana border. We have a lot of commuters that are part of the workforce that drive into Shreveport or drive to Texarkana or Longview or Marshall to vote, or to work, and then they drive back to vote, and they can vote at any location. Our poll workers are who shifted us to go to countywide voting because they had such frustration with voters who were coming in and they were at the wrong location. They hated to turn people away. So countywide voting is a huge success for us. My concern with this bill is that if we don't define precincts, I understand that we're trying to fix a problem in Harris County is what it sounds like. Maybe bracket the bill so we don't burn my house down to fix your house, because it's working in our county. But if we have to put a voting precinct, like a countywide precinct in every precinct, a voting precinct, that's 18, that's 7 new machines. You have to have 2 machines at each location. We'd wind up spending $140,000 to try to find, and we've got precincts that have no public building to go vote in. It doesn't meet the ADA requirements. In fact, we don't have internet access at one of our former polling locations. There's no cell phone access or internet access. We'd have to buy Starlink and hope for good weather on election day in order to vote. So it really depends. And so I hate to be against a bill that I know you're trying to fix a problem, but this is one of those things where we run into unintended consequences when we use a cookie cutter approach, one size fits all solutions kind of deal.
Thank you, Judge. Members, any questions? Thank you, sir.
Thank you for your
being
time
here.
today. I appreciate it.
Thank you. Chair calls Dr. Laura Presley with True Texas Elections. Hello, ma'am. I show you registered as Dr. Laura Presley. You're representing True Texas Elections, and you're neutral on the bill.
Yes.
Okay, well, welcome. You may proceed.
Thank you, Chair. I'd like to explore a couple of other unintended potential consequences of this bill. If we're requiring countywide locations to be in each voting precinct, you're going to make the voter secrecy issue way worse. Because that issue is when there's a few voters from a certain precinct at a location. This is going to make it way worse and exacerbate the ballot secrecy problem. I'll give you some examples. Today, as we sit here today, Election Day countywide locations, about 2 to 5% of voters' ballot secrecies are breached because you have a lot of sites and a high opportunity for onesie, twosie people going to those sites. Where early vote, when you have lesser sites, it's about 1 to 2% of voters, because now you've got fewer sites, more people at those locations. Does that make sense? Does the math make sense? So by now making a countywide in each precinct, your voter secrecy is way, way more breached. You can say, well, we're redacting that information from the public. Well, that's good, but the election officials still have how we vote. So now what's going to happen is the election officials are going to have more how people vote, that they can go and look it up. I think, I don't know what the answer is, but I think going back to the drawing board a little bit might help the Harris County issue. And I get it, but these are unintended consequences about the ballot secrecy.
Thank you, ma'am. Members, any questions?
Any questions?
Thank you,
y'all.
ma'am, for
Bless you.
coming
Thank
up.
you.
Chair recognizes Ed Johnson with Harris County Ballot Security and Self. Sir, I show you registered as Ed Johnson. You're representing Harris County Ballot Security and yourself, and you're here to testify for the bill.
Yes, I'm receiving a phone call at the same time, I tell you. Sorry about that. Yes, I am.
Okay, well, you may proceed.
Yes, so hopefully I didn't sign up fast enough. I wanted to be up at the front of the list. Start with when in the definition of this, it says election precinct. That is not every voting precinct. That could be a precinct or a combo in the election code. And what Mr. Moore said is true. The election code got broken last session, and counties over 1.2 million can't combo anything right now. But I'm hoping, Representative Brucey, that we get that fixed to where we go back to having large precincts combo. So if that is the case, this is a great bill. What has happened with countywide voting when Lubbock and Galveston County put it into place is they took 60 years of hard work that y'all have done up here on how to locate polling locations, how to pick judges, all the other rules you do for voting, they threw it out the window. And they gave all that authority to an unappointed election administrator that's now making these decisions. So what this bill does is still let you countywide vote, but it's putting all the hard work that this body did in coming up with rules of how you vote back into countywide voting. It would help with the allocations of polling locations. It would help with determining who gets to be the election judge for that polling location. And it actually, in my opinion, would be the first step in trying to fix the ballot secrecy problem. Voters still can go vote under this bill anywhere they want to, any polling location if you're countywide. In Harris County, give you an example of how this is being abused. In Harris County in 2022, there was 127 polling locations that ran out of paper, and mainly in one Republican county commissioner district. So there were 127 polling locations that got closed by lunchtime on election day in Harris County. But they weren't against the code. This code allowed them to have that many fewer polling locations in one county commissioner district than another. The code says no one county commissioner can have more than 50% of another. So one county commissioner can have 49% more polls than another, or less than another. And that gets to be a problem. If you were to break this out by state rep district in Harris County, it would actually be that the low end of this would be 19 polls in one state rep district on election day, and the high end was 36 polls in one state rep district on election day. 17 polls different. That's a big difference. If you take the election judge problem, Harris County received 45%. The Republican candidate for governor received 45% of the vote. Democrat received 55%. But the actual election judges were only 30% Republican, 70% Democrat.
Thank you, sir. You've reached your time. Members, any questions? Ms. Swanson?
I really appreciate the explanation, because otherwise it sounds like the bill's doing something that it's not doing. And so will this bill make counties that are doing countywide voting open more polling locations?
No, actually, it would be fewer if we get the election code fixed for the large counties.
So we would have to pass the SB 985 also?
Yeah, you have to pass SB 985, and that fixes the election code from where it got messed up last session for large counties. But currently, small counties can combine up to 5,000 voters into a precinct. So take where I spend a lot of time, a little bitty Lee County, Giddings, Texas, has 17,000 voters. They currently open 8 polling locations doing countywide, but if they could combo, they could reduce that down to 4 If they can combo up to 5,000 voters in a polling location, they could drop that down to 4 polling locations if they want to. I will tell you, this will enable counties to reduce probably smaller than they can under countywide voting. Harris County when we started, before they started countywide voting, was 700 polling locations. They started countywide voting and they went to 800 polling locations. And this bill, if we get 985 in there, they would probably be able to get down to somewhere between 600, about 550 to 600 polling locations would be able to get down to. So it's going to enable counties, and that's how we should have started countywide voting instead of making these vote centers. We should have just fixed the rules for comboing precincts so that they could combo precincts together to make larger voting areas.
And still let people vote anywhere in the county.
And still have people vote
Right.
anywhere in the county.
So how does this fix the secret ballot problem?
So the secret ballot problem, how you're going to, the Matt Rinaldi problem, how you're going to keep people from a precinct voting in a area on a particular day or in a particular race is you're going to have more voters in a precinct. Okay, it's going to put a big job on you guys. You're going to have to wait till next redistricting to fix this. Okay, because you're going to have to draw your lines to where you don't make a little bitty precinct that's only 100 voters or 20 voters or whatever, and that makes this problem where now you have so few voters that you can tell when that person went to vote. You need to have a precinct of about 2,000 voters. By putting this in, you're going to put it all back into precinct voting where county election officials can start doing combos and comboing precincts up so they can get their polling locations. And then next redistricting, y'all could use that information to help you draw your lines around these areas so that you have these larger precincts where you have at least 2,000 voters. And that way, the odds that you're going to have one person voting in one location drops dramatically. But this is the first step. I would give the election officials the ability to start working on how can I make these combos so that when y'all get to redistricting, y'all could use that information to help draw your lines so you're not splitting off little bitty sections.
Right. There was discussion back during the interim, and I remember Ms. Adkins bringing that up, that perhaps we could make it where there were fewer offices that cannot split a precinct. That's the biggest problem there.
That's how you're going to have to fix. And you will never be able to 100% fix the ballot secrecy problem. It has been around since we started voting, on this system, because there's always the chance you're going to have some small election where you have only one person vote on one day. It could be a real low turnout where you get 0.5% of the turnout, and they do it. But the larger you make those precincts, the odds of that happening radically decrease.
Okay, and you did also talk about the real problem with the allocation of election judges, and that once we got away from precincts, where even if we were comboing them, then you mentioned the numbers. It's just very
under countywide
unfair.
voting, it's up to the election administrator to determine that polling location, wherever that countywide polling location site is, of what they think that party is, to then try to appoint a judge there. So there really is no hard set rule as to what party gets to be at what polling locations. The election administrator is making that up. Under precinct voting, it was whatever party's gubernatorial candidate won that precinct, that party got to be the election judge, and the other party got to be the alternate. So by putting this back, putting the rules of the precinct voting back in, that would help determine who gets to be the judge of these locations. You can combo them up, and then it would be if you pass 985, it would be the whatever gubernatorial candidate won the combo.
Okay, great. Well, thank you.
Members, any other questions?
Yes, Chairman.
Ms.
Please.
Morales Shaw?
Thank you, Mr. Thompson, Johnson, for always having such great explanations. And we want people to be able to go to polls that are conveniently located so they can cast their ballot. You talked earlier about the 49% that is allowed between commissioners, right?
Correct.
Does that correlate with population? Because that seems like a gross disparity. But if it's based on population, then it would make more sense.
No, it is not based on population. It is based on, you have 4 county commissioner districts in every county, and you're supposed to divide the polling locations among them. And in the code, they took this out of early voting. This is actually the language from the early voting. They took it out of there, and they left out a whole section in early voting that was in there. And it just says that as long as no one county commissioner has twice as many as another, you're fine, no matter what the population of the county commissioner district is or anything. Because I know there are some counties that have the city down here and the rest of it's all rural, and there's hardly any voters up here. So going back to putting them in precincts where you would have a situation like that, you're going to have voting precincts, and the maximum size they would be is 5,000. So that would guarantee every 5,000 voters would have a polling location in their neighborhood to go to. You know, it'd be groups of 5,000. And then you could appropriately locate these polling locations around the county. So if the city's down here in the southern part of the county, like Lee County, where Giddings is, well, you're going to have more voting precincts down here than you are up around the Lexington area up here in the north, or, you know, somewhere. So this better allocates the polls. That's why I was talking about the allocation. This better, I think, addresses the allocations of the polling locations, because you put it back into the commissioners, elected people, to draw these precincts. They can't exceed 5,000, and they can put them around the county where the population lives, and then that's where you're going to put your polls.
And does SB 985 address that at all, or is it just
Well,
a
so
different
SB
remedy?
985, the mistake in there is it just said that counties over 1.2 million can no longer do combinations. So if you're a county under 1.2 million, you're still fine, but it's just the large counties that it messed up. And that needs to be fixed, because this last November, all those large counties, all doing countywide voting, still had to open twice as many polling locations because the comboing rule was removed. So fix the comboing rule for the large counties, and this works great.
Got it. Thank you.
Members, any other questions? Thank you, sir.
Thank you.
Chair calls Kathy Hagler, representing herself. Hello, ma'am. I show you registered as Kathy Hagler. You're here representing yourself, and you're here to testify for the bill.
That's correct, Mr.
Okay, you
Chairman.
may proceed.
Okay, and I think y'all heard Representative Paul said that they're going to try to address the fiscal note in the committee substitute, and I really can't wait to see what that substitute looks like. But as we mentioned, Senate Bill 985 would allow combinations, and even though there would be combinations, you can still vote countywide. That means there's less staff needed, less equipment needed, so I think it's a savings. So I think the biggest problem we have is that some polling places are clustered like half a mile from each other, while other polling places are miles and miles and miles apart from each other. And we saw this back to the infamous Harris County running out of paper ballots, the card stock, where the little precincts that were right across the street from each other or catty-cornered across the intersection from each other, they were able to easily share with each other, while the other ones that were out in the Netherlands had a hard time getting ballots. So really, this is more about equal access for all. Everybody gets the same opportunity to have a polling place close to you with a line that's not a lot shorter or longer than someone else's. We're trying to make more equal access for the voters. It doesn't push us into precinct voting, but in a general election for state and county offices in my county, I know that our county election board basically just pretty well goes along with whatever the elections administrator suggests. They don't want to do the homework to do it themselves. They don't listen to input from the community. Just whatever the EA says is what they do. So that's why I think we need to give some more direction to the EAs. And I think of this I'm getting a visual. You're dealing a deck of cards. Here's all the polling places, and it's you get one, you get one, you get one, you get one. Okay, you're going to get two. You're going to keep all one, you're going to get two. So you're going to make sure that they're very equal or similarly equal. You don't have somebody getting 20 cards while somebody else gets one. So we're trying to make sure that we have the same number of polling places, close to the same number of polling places in each district. And then, of course, as Mr. Johnson already testified, this is going to help us to have more representative presiding judges and alternate judges based on the way that the votes came in that district. That's all.
Thank you, ma'am. Members, any questions? Thank you so much.
Thank you.
Chair calls Christina Atkins with Secretary of State's office. Hello, ma'am. I show you registered as Christina Atkins. You are representing the Texas Secretary of State's office, and you are neutral on the bill.
Yes, sir.
Chair Busey.
Thank you, Mr. Chairman. There's some confusion in testimony. Can you walk us through what this bill would do? One as a standalone, and then two maybe in coordination with other bills, because I think we need to take it up on its own first.
Yes, sir. So for the bill as filed, what this is doing is it's repealing some of the provisions related to countywide voting that deal with the methodology in determining how your polling places are allocated across the county. One of the rules that we sometimes hear concerns about is one of the ones that's repealed, and it says that you can't have more than twice as many polling locations in one commissioner's precinct than another commissioner's precinct. And that's one where I think there's been testimony that explains, what those concerns might be, that there may be, depending on how many locations you have, that allocation could disproportionately impact voters in certain commissioners' precincts. So instead of relying on that methodology, what the bill is doing is it's saying you can still have countywide polling places, but they have to be based on the voter registration precinct, the location of those different voter registration precincts. And so everybody can still vote anywhere in the county on Election Day, but all of the locations that are open are the locations that would have been open had you had precinct-based voting.
So that's this bill as filed.
That is the bill as filed.
So would that mean in a county with 80 precincts, we're going to have 80 poll sites?
Yes, sir, that's correct.
So how does this coordinate, hypothetically, some other person passes a bill that we've been talking about?
So I will say.
Then what would happen?
Yes, sir, I'm sorry.
If we're allowed to talk about that.
If it's in context of this bill.
Yeah.
So what I would say, and I've had some conversations with the bill author's office on this particular issue, that there were some provisions in the code that were previously repealed that allowed counties to combine their very small locations with adjacent precincts so that they would only have to have one location open that services multiple precincts in that area. One of the things that I discussed with the bill author's office is that since that language is not in the code anymore, that hinders your ability to reduce down your locations for countywide. And so I think there's been a discussion as to whether some kind of language that addresses that issue could be included in a committee substitute. And I think some of the testimony that has been brought up today is that there is currently a bill in the Senate that's moving that addresses this particular issue. And that I think in that language in that particular Senate bill addresses the problem, and it would give counties the ability to reduce down their locations so that polling places would still be based on those individual voter registration precincts and geographically where those are located, but those precincts could be combined. You could combine multiple precincts to have one polling place serving a bigger territory.
Can you walk us through how that process works real quick? Because I think there was a lot of questions about population, geography, distance. Can you just tell us how it would happen if that bill passed or how it used to be?
Sure. So with that language, when we redistrict and when we create our voter registration precincts based off of redistricting, we have certain rules in the election code that we have to follow. Some of them are based on population. Some of them are based on the way officer lines fall. And in fact, in Texas, we have some of the most restrictive rules when it comes to drawing our voter registration precincts because we can't have more than one state representative district, state senate district, a congressional district. There's a list of different offices. You can't have any more than one of those in a particular voter registration precinct. So the way you overlay those lines, it can sometimes result in very, very small precincts in order to make sure we don't have overlapping House district lines, for example. And so to solve that problem of very, very tiny precincts, we had previously had language in the law that said when you have a very small precinct that has less than, what the law said was 500 voters in that precinct, you could combine it with a neighboring precinct to prevent unreasonable expenditures related to workers, equipment, locations. And so that was a very common practice that counties have relied on for a number of years to prevent them from having to open a polling place where they in a precinct that has 10 voters, when across the street they already have a polling place that's serving 2,000 voters. They would just combine those two together so the voters were being adequately served with a polling location that meets their needs, but it prevents those unreasonable expenditures.
Thank you, Mr. Chairman. Thank you.
Members, any other questions? Thank you, ma'am, so much for being here.
course.
It's very helpful. Is there anyone else who wishes to testify on, for, or against House Bill 4275? If not, the chair recognizes Oh, okay, sorry, Mr. Paul, we have one more individual. Ma'am, you want to come forward and we can get you registered, or did you register already and just,
I think I registered.
just not to testify? What's your name?
Susan Valiant.
No, you're fine. I'll just begin here. Oh, wait, it is down.
So you're registered, we're just going to change your registration
I
to
thought I
testify. If
did.
you just wait one moment, and
Okay.
we'll take care of you.
I thought I did. Wasn't quite sure or not.
Okay, ma'am, I show you registered as Susan Valiant. You are representing yourself and Texas First Elections Group, and you are here to testify against the bill.
Yes, and SREC SD10.
Okay.
Sorry.
Okay, so you're Susan Valiant, you're representing yourself, SREC, SD10, Texas First Elections Group.
Yes.
Did I get that right?
Yes.
And you're still testifying against.
I'm
You
still-
may proceed. All right, thank you, ma'am, for your
Well,
patience.
I could be for it, but just with some changes. I'm not sure. I mean, you keep talking about SB 985, but its companion bill is HB 342 that y'all have already passed through this committee as far as combining precincts. And so I wasn't sure if y'all were aware of that part or not. And I think it's in calendars. Y'all have referred it to calendars.
Yeah, I think there
And
was
that's
a
the combining.
I think there was a dialogue about this piece of legislation and some of the code that it was touching and some other bills that was also touching that code. I think
There's
that's why
7.
some other, so
That it touches.
that discussion was in context of this legislation here.
Okay, yeah, I just wanted to make sure that y'all were, yes. But we're talking about 90% of the voters actually vote close to their home. So all we're talking about is 7% of the voters who vote outside of their precinct when we're talking about this countywide voting. And as far as the secrecy of the ballot, I know that they want to contribute that to being small precincts, but it's not just the small precincts. That's only less than 1% of the population that actually that happens to. 7% of the voters that turn out is actually due to the countywide voting. I mean, I did the Tarrant counties. Actually, I did all 96 counties, but in Tarrant County, I did the Tarrant County Plaza voting location, and out of a little over 800 voters, I identified 130 voters at that precinct that I could see their ballots. So that's kind of, I mean, it's not just the small precincts that actually you can identify the secrecy of the ballot. That's only 1%, but we can fix the 7% by going back to precinct voting, which that's what this bill sort of does, other than it's still countywide. That's just going to split the votes even more so, and you're going to be able to identify more voters at the different locations. If we're going to have that many, if we can combine and we can go back to precinct voting, then that's going to be where it's going to be better elections, it's going to be more secure elections, and more accurate. And I hope that you would consider those changes. Any questions?
Thank you, ma'am. Members, any questions?
Thank you.
All right, well, if you can come right back up, we're going to just make doubly sure we have you registered correctly.
Okay.
And we do that just because there's rules that the House has to follow.
Oh, sure.
And we have to do that in committee. So I showed you originally testifying just for yourself.
Yes.
And then, but who are you, who's everybody you're representing now?
I'm representing myself.
Yep.
I'm SREC SD 10
Yep.
and the Texas First Election Group.
Perfect. That's what we have.
Okay.
Okay. So I just wanted to double check to make sure. Thank you
Sure.
for being patient
Sure.
with us, ma'am.
Thank you.
Is there anyone else who wishes to testify on for or against HB 4275? If not, the chair recognizes Representative Paul to close on the bill.
I appreciate, Mr. Chairman, as you can see some of the conversations going on. The changes that we were putting in the committee substitute basically will match the Senate bill that we were talking about and fix that. The intent was always to make sure we have combined as precincts, as we were having discussion with Ms. Shaw before. But we'll make sure it's clearly that is the case, that we're going to be able to make sure you combine these. We just want to make sure that they're evenly distributed, these combination precincts are evenly distributed amongst the county so that we can have even voting. With that, I close.
Thank you, Representative members. Any questions? Thank you, sir. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 1638 and recognizes Representative Morales to explain the bill, and the chair offers a committee substitute.
Before Chairman Paul leaves, you got to remind him that he owes Representative Gerdes and I at least a drink or something for making us wait this long.
I hear you. You may proceed, sir.
Chairman Shaheen, thank you for the opportunity. Good afternoon, Vice Chair Busey and members of this committee. It's good to see my replacement, Penny Morales-Shaw, up here. I'm getting a little bit of PTSD from listening to the testimony. I served in this session, in this committee, and it was an honor for me to serve in this committee and to be able to listen to all of the work that you all are doing. Thank you for what you all do. So it's great to be back in this committee and see so many familiar faces in the room. Last year, the City of Alpine City Council passed a resolution in support of changing their municipal general election from May election to November. So we've honored that request by drafting this very bill. HB 1638 does just that. This is a simple bill that would allow the City of Alpine to change their election to the November general election date. This bill would give the city until 2027 to make this change. If they do not, this section will expire. I'm happy to answer any questions you may have. I don't believe that there's any witnesses, so we're making it fast, efficient, and easy for you, Chairman.
There are not. Members, any questions? All right. Chair recognizes Representative Morales to close on the bill. Wait, hold on. Oh, I'm sorry, I skipped a point. Is there anyone else, or is there anyone that wishes to testify on for or against House Bill 1638 and its committee substitute? If not, the chair recognizes Representative Morales to close on the bill.
Thank you again, Mr. Chairman. I will mention the Senate companion has been received by the House. It passed unanimously over there. I understand you've laid it out also. So with that, I'd ask for a favorable vote from this committee, and I appreciate the opportunity to present this bill before you.
We laid out the committee substitute, not the Senate
Correct.
companion. Yeah.
Sorry, for the record.
Yep.
Correct.
The committee substitute is withdrawn. Is there no objection? The bill will be left pending. Is there objection? Chair hears none. The bill is left pending.
That is the only matter I have before this committee. May I be excused, sir?
Yes, sir, you may. Although we're going to miss you. If you want to hang out with us, you can.
Thank you all.
Chair lays out, hold on one second here, Garcia. Chair lays out HB 2785 and recognizes Representative Garcia to explain the bill.
Thank you, Chairman Shaheen and Vice Chair Busey and members of the committee for the opportunity to lay out House Bill 2785. This bill came about because of some of our constituents mistakenly believe that completing the voter registration application request form online is sufficient in completing voter registration, which leads to incomplete registrations and confusion. HB 2785 strengthens the voter registration process in Texas by ensuring prospective applicants clearly understand that filling in a registration application on the Secretary of State's website does not complete their voter registration application. Currently, the Secretary of State shows a disclaimer after filling in the application, and their office has confirmed they are not required to have this disclaimer. The bill mandates that the Secretary of State's website prominently displays a message that must be acknowledged before proceeding with the website, informing the prospective applicants that 1, submitting a voter registration application request on the website does not complete the registration process. 2, a completed voter registration application must be printed, signed, and submitted to the appropriate county voter registrar. To ensure clarity, the acknowledgement will be presented in a clear, unavoidable format that prevents further interaction with the webpage until the prospective applicant confirms their understanding of the application process. With over 560,000 people moving to Texas between July 2023 and 2024, we must ensure that we keep our voter registration application process safe and clear. HB 2785 will ensure that voter registrations match voter IDs at the polls, help reduce incomplete registrations, and make sure that the voter registration application process more secure in Texas. Mr. Chairman and members, we have a witness here to testify on the bill, and unless there are any other questions for me, I respectfully reserve my right to close.
Thank you, ma'am. Members, any questions?
Yes, Chairman.
Ms. Morales-Shaw?
Thank you, Rep. Garcia, for a very succinct and clear layout. I just wanted to clarify, does this mean that when you go online to look at a voter registration form, that there would be like a pop-up message or something that won't let you proceed without acknowledging that, so that it's clear to the person filling it out that this isn't the end of the registration process?
Yes, that's correct. There would be a pop-up with a click. I acknowledge that I need to print this and mail it in. Right now, as it shows, if you look in the documents that I provided, it's at the very end of the registration, and we found that some of our constituents feel that in printing it, it's just like a receipt almost, and not necessarily that action needs to be taken afterwards.
Got it. And who would this bill, or what organizations would this bill be aimed at?
I mean, all Texans.
Okay, but like who provides the online voter registration forms? Is it the
Oh,
Secretary of State?
it's the Secretary of State.
Okay,
It's
okay.
on the Secretary of State website.
Okay,
Yes,
great.
I apologize.
Thank you.
And they're here as
Yes.
resource witness.
Thank you.
Thank you, ma'am. Members, any other questions? Is this your first bill layout?
Yes.
It is. Well, you did a great job. We usually haze first-timers.
I know.
But oh, that's right, and it was your birthday yesterday.
Yes.
You got all kinds of good things happening. Well,
Yes.
great job. We will reserve your right to close, and we'll proceed to testimony. Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You're representing yourself, and you're here to testify for the bill.
Yes.
All right. Well, welcome back.
Thank you. I really like this bill. There are a lot of rumors going around about whether or not Texas does or does not allow online voter registration. I had one concern and a suggestion. So my first concern is that when I read the language of this bill, if the Secretary of State adopts a procedure for the completion of a voter registration application on the Secretary of State's internet website, what I first thought it was going to mean is if we adopt online voter registration procedures, right? But so what this actually apparently is talking about is just filling out the application and then printing it out. So it's like a pre-filled application. I'm afraid that might create some confusion. So if the committee could address that, that would be great. If the language could be worked on a little bit, just to make it clear that this is about the completion of an application to be sent in, I think that would help clarify. And then my second suggestion is that the paper application that you fill out for voter registration does not include this language. So if you fill out a paper application and you send it in, you might assume that that's registering you to vote, but it's not. There's a whole process that has to go through before that. So if the legislature would like to consider, or the SOS, putting that language on a paper form, I think that would be really helpful for voters.
Thank you, ma'am. Members, any questions? Thank you for coming up today. Chair calls Emily Pinal, representing herself. Hello, ma'am. I show you registered as Emily Pinal. You're representing yourself, and you're here to testify for the bill.
Yes.
All right.
thank
Well,
you.
welcome. Thanks for
Good-
being here.
Yeah, good afternoon. So my name is Emily Pinal. I am coming from East Texas. For a little over a decade, I've been a volunteer deputy registrar of ADR in multiple East Texas counties, Smithwood, Cherokee, you name it. I've had the privilege of helping hundreds of eligible voter residents begin the process of registering to vote, and I came here today to show my strong support for HB 2785, in which strengthen and clarify the voter registration process in Texas. Although the Secretary of State website currently includes an instructional notice that a completed voter registration application is not the final step, this notice is not required by law and could be altered or removed at any time. HB 2785 would codify this essential guidance, ensuring its permanence and consistency, regardless of future administrative changes. In my years of service, I've witnessed firsthand how easy it is for individuals, especially first-time and young voters, to assume they are registered simply because they filled out an application. This misunderstanding leads to disappointment and disenfranchisement at the polls. So this addresses the gap, requiring all prospective voters clearly confirming their understanding that, one, filling out a voter registration application alone does not constitute registration to vote, and two, the application must be submitted to the appropriate voter registrar in order to complete the process. This is a small but meaningful change that removes ambiguity and empowers voters with knowledge that they need to follow through. It is a straightforward safeguard that promotes civic engagement while protecting the integrity of voter registration processes. As someone who works closely with rural and underrepresented communities, I know how critical it is that the registration process is not only accessible, but also very clearly communicated. HB 2785 is a necessary step towards that reality. Other than that, thank you for your time and on this important legislation.
Thank you, ma'am. Members, any questions? Thank you so much for being here. Good job. Chair calls Ed Johnson with Harris County Ballot Security and Self. Welcome back, sir. I show you registered as Ed Johnson. You're here representing Harris County Ballot Security and yourself, and you're here to testify for the bill.
All right, yeah, 2 in 1 day, Representative. So, yeah, no, love the bill.
Okay,
It's a great bill, in past, we've had this problem with DPS. It used to be on the DPS form that you would go through and update your driver's license and click the box that said, yes, I want to register to vote. And then, it took you never land, and you never know if you really got voted, but you had to print it out and mail it in. So that instruction is on the Secretary of State's website, but just in case they didn't see it, I think it would be good to have a little pop-up box that says, please print this and mail it in, type deal. So I think it's a good change, and it shouldn't be very expensive for a web programmer to make a little pop-up box.
Thank you, sir. Members, any questions? Thank you, sir, for being
Thank you.
here. Okay. Is there anyone else who wishes to testify on for or against HB 2785? If not, the chair recognizes Representative Garcia to close on the bill.
Thank you. I just want to add that the Secretary of State website confirmed that there would be no additional costs to make that change. Mr. Chairman and members, thank you for the opportunity to lay out House Bill 2785. Unless there are any other further questions, I ask for your favorable consideration to close.
Good job. Members, any questions? Excellent. Thank you. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill. You've been applauded twice. That's pretty impressive. Chair lays out House Bill 2316 and recognizes Representative Gertis to explain the bill.
Thank you, Mr. Chairman. This is not my first bill layout.
You're probably not going to get any applause either.
I'm not
sorry.
going to get any applause, but let's get right to it. Across the state of Texas, it's common practice for counties to report their election results with raw vote total, along with a total percentage of votes received. This same common practice is adopted by the Secretary of State's office when they report vote totals as well. However, this is not currently required in election code, and unfortunately it created a small problem in my district. In Caldwell County, their results are reported only via raw vote totals, not percentages. This has led to some confusion among locals, including almost incorrectly calling for a primary runoff in a constable race. HB 2316 simply codifies this common practice of reporting percentages of the total number of votes. Thank you, Mr. Chairman, and if there's any questions over.
Thank you, sir. Members, any questions? Thank you. We'll proceed to testimony.
The chair calls Kathy Hagler. We show you as Kathy Hagler representing yourself, and you are for the bill. Is that correct?
That's correct, Vice Chair Busey.
You may proceed.
Thank you, sir. I'm very thankful that my state representative, Stan Gerdes, has filed HB 2316. As he mentioned, we had a little confusion in Caldwell County on the night of the primary last year. As you can see from my handout, we had 3 candidates in our Constable Precinct 2 race. There are only 4 rows of numbers on the election night reports. 3 rows were for each of the candidates, and the 4th row said contest totals. The problem is contest totals is not defined anywhere. So folks with low math skills would probably look at that contest totals of 1510 very quickly and say, oh, well, the highest vote getter got less than 700 votes, so, oh, we're going to have a runoff. And we had folks thinking that we were going to have a runoff, and that would be incorrect. Contest totals is actually how many people voted in the Precinct 2 election, but it includes the number of undervotes. We don't have a separate category showing for undervotes. So contest totals is actually including undervotes, which don't go towards the election results. So, and they don't determine the winner of a race. So Election Code 72.003 cleared this up for us. And so my second chart that I've got showing you there strikes out the misleading contest totals, and the bill does not strike that. We still want to know undervotes. We still want that information. But just for the sake of testimony, I'm just taking out contest totals, and I'm showing you the actual number of votes. And with that, you see that there were actually 1,349 votes cast. And when you divide candidate A's 694 votes by 1,349, he actually got 51.45% of the vote, no runoff. And I did find out from someone today, thank you, Mr. Eller, that there's actually just a little box that the tabulation supervisor can check when they're saying what elements they want to show on their report, and it's very easy to do, but unfortunately, they're not required to do that by law, so this would just make that mandatory.
Members, any questions? Thank you, Ms. Hagler.
Thank you.
The chair calls Ed Johnson. We show you as Ed Johnson, Harris County Ballot Security, representing Harris County Ballot Security and yourself, and you are for the bill. Is that correct?
That is correct.
You may proceed.
Great bill. I will tell you, it's good that they have the little box they can check and pull this out electronically. You got to remember these candidates and election workers probably got up at about 3 or 4 in the morning before Election Day to go put out signs and been working all day, and it's usually after midnight before you finally get the last results in. And people's math abilities, as the hours go on, tend to drop. So it would be a very good thing to have the computer spit out what the percentages are so you don't end up with false rumors going out of runoffs or not runoffs.
Sounds good. Members, any questions? Thank you, sir.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 2316? If not, the chair recognizes Representative Curtis to close on the bill.
If there are no further questions, I close.
Thank you, sir. Members, any questions? Thank you, sir. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. Chair lays out House Bill 3113 and recognizes Representative Troxclair to explain the bill. And the chair offers a committee substitute. Hello,
Hello
ma'am.
there. Man,
Hey
it's a
there.
busy day today, isn't it? Everybody's running around, running around, laying out bills and with budget up tomorrow. Mr. Chairman and members, thank you so much for the opportunity to hear this bill. I believe we have a committee sub. Has that been laid out? Okay, great. So this is a straightforward but important measure that addresses both election and security and administrative efficiency. It simply requires that in counties where hand counting of paper ballots is used, those ballots are capable of being counted mechanically in the case of, for example, an election contest or audit. Let me be very clear, this does not in any way prohibit or impact the practice of hand counting. And in some counties across Texas, this is the way that our elections are being conducted, including in my district. So of course does not prohibit that, but it is important that the actual paper that is used is able to be mechanically counted. You can't, if you create your own ballot and therefore it is not able to be mechanically counted, we run into major issues complying with existing law in the case of an audit or a verification or a court order, because there is no way to run those ballots through any kind of mechanical counter that can confirm that vote. The committee substitute updates the terminology and code to refer specifically to optical scanning equipment, which is more accurate and a modern term than automatic tabulating equipment. This was a change that was made in response to some who brought concerns about machines that are connected to the internet. So I just want to be very clear that the ballots, the optical scanners, are not connected to the internet. Also want to be very clear that this doesn't require that any entity purchase certain machines or purchase certain ballots. It just says that you have to use a format that is recognizable and acceptable. This way, we can ensure that we have voter confidence, that we're maintaining a paper trail, that counties have the flexibility to run the elections as they see fit, but that we also have the ability to catch cheaters and make sure that there isn't anything inaccurate going on, because we all agree that election integrity is important. So, with that said, I am happy to answer any questions and very grateful for your thoughtful consideration.
Thank you, ma'am. Members, any questions? Thank you, ma'am. You'll reserve the right to close, and we'll go to testimony.
Thank you.
Chair calls Andrew Eller, representing himself.
He's not testifying.
Okay, we probably need to update. Is he? Okay, we just need to update. Chair calls Jeanette Hormuth. And with the Fredericks Tea Party and yourself, or no, I'm sorry, that's not accurate. You're representing yourself. So let me repeat that just so I get the record straight. So you're Jeanette Hormuth, you're representing yourself, and you're here to testify against the bill?
Yes,
Okay, well, thank you, ma'am, for being here. You may proceed.
thank you.
Yes, I'm Jeanette Hortmuth. I've been a poll watcher and a trainer, as well as Fredericksburg Tea Party election integrity focus leader for the past 6 years. I'm strongly opposed to this bill, which would force hand count counties to incur unneeded expense for scannable ballots. Last spring, I had the extreme pleasure of participating from the ground up in the successful Gillespie County Republican Party primary hand count election and runoff. There I witnessed firsthand the transparency, accuracy, and audibility of the hand counting of ballots provides, and the built-in triple verification of the vote count in real time. As a result, the votes recorded on the original tally sheets and the final canvas totals official in both the primary and runoff hand count elections proved to be 100% accurate and timely. And this is contrary to some of the stuff I'm hearing, this just outlandish rumors about some of this information. So I'm here to say I was there and I was part of it. This bill seems to have a big disconnect. Counties that are working very hard to go to hand count, counties that are already hand counting would be forced to pay additional expenses for these ballots. And why do these ballots that are will work on these machines if you're not going to end up having to use these machines at some point? More and more counties in Texas and our nation are moving away from the vulnerable, non-transparent, expensive electronic election systems and are instead moving towards a more fully transparent, verifiable paper ballot hand count process. HB 3113 is pushing upstream against the current by mandating hand count counties to contract with machine vendors for these scannable paper ballots to be used in electronic tabulators, or she's saying mechanical machines. There's no such thing. These are all electronic. Why should counties who choose to hand count, like us, or who are considering returning to hand count, be forced to contract with the very machine companies they are trying to separate from? People are trying to move away from all this complexity, these machines, this vulnerability. And lastly, why should small counties such as Glasgow, who have already hand count their elections, or Gillespie, like us, who wish to return to hand count, be financially burdened with such an unnecessary expense? Are they being penalized for or deterred from choosing to hand count?
Thank you, ma'am. Thank you very members, are there any questions? You're good. Thank you, ma'am. Chair calls Angela Smith with Fredericksburg Tea Party and self. Welcome, ma'am. I show you registered as Angela Smith. You are representing the Fredericksburg Tea Party and yourself, and you're here to testify against the bill?
That is correct.
Well, welcome. You may proceed.
Thank you. My name is Angela Smith, and I thank you for the time today. Fredericksburg Tea Party opposes HB 3113 for many obvious reasons. Counties seeking to hand count would be forced to purchase costly and unnecessary scannable ballots with barcodes. They're impeding the hand count process. President Donald Trump has issued an executive order prohibiting barcodes on ballots. And not only has that happened, in February of 2024, Georgia passed SB 189, which removed the QR code, a type of barcode, from printed ballots, saying that they wanted to bring back the voters feeling like their vote is actually being counted. The future of election integrity is free from costly vendor contracts and primed for no-nonsense, citizen-based execution of elections. That's why FTP believes that HB 3113 appears to impede hand counting by mandating additional and unnecessary costs, while President Trump's vision to reinstate trust in our elections is noteworthy. In the near future, we believe that barcodes, vendor contracts, machines, and the like will be a thing of the past. I'm open for any questions.
Thank you, ma'am, very much. Members, any questions? Thank you so much for
Thank
being
you.
here today.
Thank you.
Chair calls Dr. Laura Presley with True Texas Elections. Welcome back, ma'am. I show you registered as Dr. Laura Presley. You are representing True Texas Elections, and you're here to testify against the bill.
Yes, thank you.
All right, well, welcome back.
Thank you, Chairman. This is a vendor bill. This is a bill that will force counties to get into contracts for ballot formatting for scannable features on the ballot. I'm a little confused about the layout of the bill. Mechanical ability to detect how someone votes on the state rep said mechanical. That's, for example, ballots that have a physical hole in them or something like that. That's mechanical scanning. What the bill talks about is scanning means electrical. So I think the bill layout of the mechanical ability has to do with punch cards. We don't have mechanical anymore. We have electronic, scannable, optically scanned devices. Today in the state, the only scannable technologies are the ballot can be scanned, the little dot that you mark, or the barcodes. And as the previous person just said, the barcodes in 6 months are going to be decertified across the country, according to the executive order from President Trump. In the handout that I gave you, I have highlighted the executive order from President Trump that says barcodes within 180 days will be decertified. Also, I have an example of a mail-in ballot that will be scanned. You can scan it and find the dot on it. I have a ballot from Williamson County that shows where the barcodes would be for the votes for the candidates. And actually, this is a redacted ballot from Williamson County. Basically, they're redacting personally identifiable information in the barcodes. You can't make it up. I thought the barcodes are only supposed to be candidate information, but it's redacted because there's personally identifiable voter information in the barcodes. So this is one of the main reasons why these things are going away, because you can't trust what's in these codes because you can't they're not human readable. The last one is a Hart ballot, which is the QR code. This is Hays County, Tarrant County, Harris County. So I am completely against this bill for multiple reasons as laid out. And I'm here if there are any questions.
Thank you, ma'am. Ms. Isaac.
Thank you, Mr. Chairman. So I know for a fact that this language came from Phil Waldron. Do you know who Phil Waldron is?
I do know him.
Okay. We
Yeah.
spoke with him, and this was his language. So Phil Waldron is known for the PowerPoint, came in a prominent figure with the Trump administration, helping the Trump administration with election fraud.
Yeah.
And if I have this correct, like when I was in school, I used to have to bubble in a little form with my pencil. And what this scanner does, the specific language in her bill, it just scans that little bitty image. It cannot be connected to any Bluetooth, any internet. This is the most secure and effective and efficient way to count this. And he actually proposed this.
Right, and they proposed this before the executive order came out. Months before, it was about a month or so, 2 months before. So the bill does not say excluding barcodes and QR codes because that is scannable. So I've talked to the author and have made that request, but I also think that this mechanical method, I'm not sure where that came from because we don't do mechanical anymore. We just do electrical scanning. Okay, does that make sense, Representative?
I think so. I think
Yeah.
we're maybe talking past each other.
Yeah.
But,
So-
so you're saying that maybe with some perfecting, like,
Of scanning the barcodes and the QR codes. Also, I'm against it because it causes counties that do this right now or that want to go to it, they'll have to have contracts for formatting because the scanning is an XY location, right? That's how it's scanned. It does an XY coordinate. That has to be formatted. You have to have licenses. And I'm wondering if the author actually talked to any counties about this. For example, the counties that want to do this. I know Dallas County wants to go to hand-counted paper ballots in their primary. Have these people been talked to about this before it got proposed?
do you believe this is more of a burden and more expensive than the machines?
I think for the hand count, that to add this cost on top of it, I don't think it's needed.
I mean, you're talking about having to have a special format, and then a little scanner or scanners.
Yeah, you'd
You
have to
think
have a
it's more-
contract. You'd have to have this is a vendor bill. You'd have to force counties to get into a contract to make this happen, even when they don't want to.
I don't see it that way, but thank you.
It says requiring counties to do it. It's not an option.
It's not a vendor bill.
It is a
but-
vendor bill because it's going to cost money. It's going to cost counties money to get into these contracts, to format these ballots into that XY coordinate for
Okay,
those
when
dots.
you say vendor bill, to me, what you're saying is that a vendor person that's selling these machines came to the author and asked for this bill. That is not what happened at all.
No.
Okay.
I'm not making any assumptions of who came and said what. A vendor bill is one that will cost counties money and they don't have a choice. And it benefits two vendors.
Okay, thank you.
Okay.
Members, any other questions? Thank you, ma'am, very
Thank
much.
you.
Chair calls Laura Rogers with County and District Clerks Association and yourself. Hello, ma'am. I show you registered as Laura Rogers. You are representing County and District Clerks Association and yourself, and you are here to testify for the bill.
That is correct.
All right, well, welcome. You may proceed.
Thank you. Good afternoon, officially afternoon. Like you said, I'm Laura Rogers, and I'm the County and District Clerk in Sherman County, and I'm here to testify in favor of the bill. I agree that this is not a vendor bill. This just will simply help with the auditing process. If we needed to go in and have an audit done, we would have the option to have those scanned and not have to completely redo the hand count. So I just wanted to testify in favor of the bill.
Thank you, ma'am.
Thank you.
Members, any questions? Thank you, ma'am. Chair calls Jim Raleigh, representing yourself. Hello, sir. I show you registered as Jim Raleigh. You're representing yourself, and you're here to testify for the bill?
That's right.
All right,
Thank
well,
you
welcome,
for-
sir. You may proceed.
Thank you for the time. I am the EA for Gillespie County. And the reason that I look at this bill and think this is a good idea is because you've just heard that we had a 100% successful hand count. That didn't exist. We had a difficult process. Hand counting is a good thing. If you want to do it, that's fine. But if we'd been able to scan those ballots, we could have had a benchmark, a line to measure against that would have helped in the subsequent issues. 12 of the 13 precincts that turned in final tallies for the unofficial first count were wrong. 12 of the 13 final totals. Of those totals, the judges all came back in and worked for a whole week. Nobody knows how many mistakes they found, the numbers between 900 and 1,200. These aren't illegal things. These are those clerical issues that happen when you get involved in something that is so monotonous. I can't put it any other way. Count, count, count. It's not an easy thing to do. Once those judges came in, found the errors, we then canvassed. We even found errors in the early voting twice. The first time when the judges came in and the day of the canvass. What cannot be determined is the number of errors that led up to the final errors that were turned into my office. What started those? Did a specific error begin with the caller, the echo, the recorders? Were the errors simply just clerical? Were errors added by those who had a particular candidate in mind? None of that is true, but the suspicion remains. Unreadable penmanship, simple math errors, transposing numerals. All of those things made a difference in whether or not we were accurate. The cost of ballots, by the way, is the same, whether you are scanning them or not. The barcodes on a Hart ballot, and I can only speak for one vendor since that name has come up, same cost, and the barcodes on there are simply identifiers of that ballot. Which candidate goes where, which little box goes where. There's no recording, and that's what the EO, by the way, refers to. There's no recording of the ballot on a barcode. I'll leave it at that.
Yes, thank you, sir.
I'm in favor of the bill.
All right. Members, any questions? Ms. Isaac?
So you don't see this as a burden to have something formatted that it would be scannable if you have it?
Oh, I don't know. We offered actually to the party that if they would let us go ahead and use our scanners, they could hand count the complete election at their leisure after it was over. That was turned down. It would not create an extra burden, and they wouldn't have to do it. We all happy with the hand count? Everything looks good? They accept that as their party? Great. But if it's available, why not take advantage of it?
Thank you.
Members, any other questions?
Thank you.
Chair calls Ed Johnson with Harris County Ballot Security and Self. Hello, sir. I show you registered as Ed Johnson. You're here representing Harris County Ballot Security and yourself, and you're here to testify for the bill.
That is correct.
Okay, you may proceed. Thanks for being here.
Okay. So when I was in 2018, last working at the clerk's office, we had a primary election that it was like within 10 votes different of the two candidates. So of course, you know, the immediate thing you do is you go to a recount and something like that. And this was in the Republican Party. Knew both people running. We knew the teams they got together for counting. And one of them wanted to do it on paper. We were on direct electronic machines at the time. So what you do then is you have the machine print out all the ballots. And what we'd do is we'd send it out to a PDF format, and then we would print the PDF. Well, you can do a name search on the PDF. So we name searched for the two different candidates, and we knew exactly how many votes each got. They were on these pieces of paper. It took that group of, I think it was 30 people, 5 times before they got the count right, okay? So it is not easy hand counting these things. It's human error, things make mistakes. And the thing that you're going to deny in a large county is if you don't have some kind of scanning system that you can at least get to a very close count is ability of a candidate to move forward with an election contest if it was really close. Because you got to make that right away before you do the canvass of the election. And that's only like a week's time. So you don't have time to sit and hand count all these in a recount and then decide, oh, hey, I'm going to, you know, try to do an election contest because I think there was something rigged here. So you need this recount done quickly if this candidate is truly going on the path of a challenge. It makes sense to have this also the other one in a large county, like Harris, if it was going to do hand count, and we even a smaller one, but in Harris, there are 500 different ballot styles. So in early voting locations, if you were doing hand count, you would have to have 500 different stacks of ballots to be able to hand to voters as they came in. Just be a nightmare. So you can't do that. What you're going to have is you're going to have a printer there that's printing a ballot upon when that voter walks in of their ballot style. And you're almost just like a vote by mail ballot. You'd print off a ballot that would be bubbled in, like the old Scantron form, and you feed it through the scanner at the end of the election, you can get a count.
Thank you, sir. Members, any questions? Ms. Swanson?
Yes, I just really like this bill. I remember the days when I spent many years being an election judge, and back in the day we had the punch cards, and as you know, it was our job to count those. We only counted how many we had. We did not count how they voted in every single election, so it'd be a true nightmare. We just had to count how many there were. And in a big election, it was very difficult to get the accurate number. You knew what number you were supposed to have because they gave you this many, you're turning back in this many, it was supposed to all match. It wasn't easy. I remember everybody, you're just counting them, you're not looking at the punch holes, and you'd have to turn the stack every 25 or whatever it was, and then you'd pass it to the person next to you to see what number they got. And sometimes we counted and counted and counted, and the one time I really put my foot down was like, okay, if we came out a little bit short, sometimes people did walk out with those ballots, and so if you lost one or two, that wasn't rare. But one time, the number they came up with had me like bringing back like 10 or 20 more ballots than they'd given me. I'm like, no, I cannot go in and say I'm returning more ballots than they gave me. We're staying here all night till we figure this out. So I just think it's totally impossible to hand count ballots, and especially now that you'd have to actually be counting the individual spots there. And this might be a question then for the Secretary of State's office, but I did wonder, for the post-election random audit, if the election was hand counted, is the audit hand counted or scanned and tabulated?
Yeah, I believe it's scanned, but ask the Secretary of State, make sure I'm correct. But this bill would be really good in being able to use those scanners so that you can get at least that benchmark where you can tell if what the candidates can make a determination of what they want to do.
Absolutely, for sure.
Because you can't take weeks to do it.
Right.
They would run out of options.
Right. Thank you.
Members, any other questions? Thank you, sir, very
Thank
much.
you.
So do we want a resource witness?
Yeah, I'd like to ask that one question.
Chair calls Christina Atkins with the Secretary of State's office. Welcome back, ma'am. I show you registered as Christina Atkins with the Texas Secretary of State's office, and you are neutral on the bill.
Yes, sir, that's correct.
All right, Ms. Swanson and then Ms. Plesha.
Oh, thank you. Yes, I don't know if you heard my question. So when you're doing a post-election random audit, if the election was hand counted, is the audit hand counted or scanned and tabulated?
So when there is a hand-counted election, there is no post-election audit.
Oh.
Our law doesn't provide for a post-election audit for hand-counted elections.
Okay.
The conversations we've had earlier today all deal with auditing electronically counted ballots. And the law
Okay,
doesn't provide
because
a
you're trying to prove to everybody that the machines are working right.
Yes, ma'am.
Okay, not that the people are working right. Okay, thank you.
Ms. Plesha.
Thank you, Chairman. So I'm just trying to kind of understand and wrap my head around. So current law, right? A local party could essentially create their own ballots like in a Word document?
For a hand count, yes, ma'am. I will say to a certain extent. I do want to give the caveat that in every election that we have in Texas, there are some default federal and state laws that require that we have ADA accessible equipment in our polling locations. Okay. There's some very, very limited exceptions where people can be exempted out from them. It's primarily water districts. But generally speaking, for the hand counts that were discussed earlier, in Gillespie County, they were required to have ADA equipment, which is a voting device to help that voter mark that ballot. So that while they had that hand count and they could generate the ballot the way they liked, they also had a ballot, or they had equipment that was programmed that produced ballots for those voters as well.
Okay, so there is no way to confirm a hand-counted vote was made in this kind of like irregular, like self-made ballot type?
In current law, ma'am, there is no post-election audit for a hand count. The only way to confirm that total would be, one, to wait till after it's canvassed and after ballots have been released to the public. So 60 days after Election Day, a member of the public can do a public information request for a copy of those ballots, and they can hand tally them themselves. Or the only other option that could exist is potentially like a court order for a recount, excuse me.
Okay, so that's essentially what this bill is trying to do, right? This bill will address that we ensure there is a way for a count to validate an election, like in a county that's essentially made their own Word document ballot.
And what I would say is that this bill provides an avenue for a potential validation. It doesn't mandate a post-election audit for
Okay.
these hand counts. But if there were a challenge to an election contest, it could be that a judge could then order some kind of electronic count to validate the hand count.
So you brought up our communities with disabilities. How would this bill specifically impact those voters with disabilities?
So right now, our elections are required to have that ADA accessible equipment. And so typically what's done is this equipment is programmed for a ballot that can be used by these individuals that may need some additional assistance. And so the programming has already been completed. What most counties would do on top of that is just generally print the ballots based off of that program. So you can produce a voter marked ballot from the same programming that you have used to program that ADA equipment.
Okay, well, thank you so much. Thank you for answering my questions.
Sure, of course.
Members, any other questions? Thank you, ma'am, for being here. Is there anyone else who wishes to testify on, for, or against HB 3113 and its committee substitute? If not, the chair recognizes Representative Troxclair to close on the bill. Great timing.
Yes. Went and closed on another bill in between this time. Thank you all for your thoughtful questions and for your favorable consideration of this bill. I close.
All right, thank you, ma'am. Members, any questions? The committee substitute is withdrawn. If there's no objection, the bill will be left pending. Is there objection? The chair hears none. The bill is left pending. So members, we're going to go vote out 2 bills, and then we have 2 more bills to hear, and we will be done. All right. Chair lays out House Bill 2259 by Diala as pending business. Members, this is the bill we heard previously relating to the instructions for an application form for an early voting ballot. The chair moves that HB 2259 without amendment be reported favorably to the House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen?
Yes.
Vice Chair Busey?
Yes.
Representative Isaac?
Aye.
Representative Morales-Shaw? Representative Plesa?
Aye.
Representative Raymond?
Aye.
Representative Swanson?
Aye.
Representative Toth? Representative Terry Wilson?
There being 7 ayes and 2 absent, the motion prevails. Chair lays out House Bill 2811 by Hayes as pending business. Members, this is the bill we heard previously relating to the date of the meeting of presidential electors of this state. Chair moves that House Bill 2811 without amendment be reported favorably to the full House with the recommendation that it does pass and be printed. The clerk will call the roll.
Chair Shaheen?
Yes.
Vice Chair Busey?
Yes.
Representative Isaac? Representative Morales-Shaw? Representative Plaza?
Yes.
Representative Raymond?
Yes.
Representative Swanson?
Aye.
Representative Toth? Representative Terry Wilson? Representative Morales-Shaw?
There being 7 ayes, 2 absent, the motion prevails. All right, members, Mr. Busey.
Yep.
Chair lays out House Bill 569 and recognizes Vice Chair Busey to explain the bill.
Thank you, Mr. Chairman and members, for allowing me the privilege to lay out House Bill 569. This is a cleanup to the ballot by mail cure bill, Senate Bill 1599, which passed in the 88th legislative session by Senator Hughes and myself. I'm again working with Senator Hughes on this legislation to add the early voting clerk to the list of individuals that can send the voter a notice of defect and corrective action form. Previously, this could only be done by early voting ballot board and signature verification committee. The early voting clerk is the first to receive the mail-in ballot, and under current Texas election law, if a mail-in ballot does not fully comply with requirements, for instance, if it's missing a signature, has an incorrect voter ID number, or there are any other clerical mistakes, it may be rejected without notifying the voter in time to correct it. I would like to say we don't make mistakes, but Senator Hughes and I left this out, and so we're just back to clean it up last time. And so it's a really simple cleanup. I'm sure if needed, the Secretary of State talked about why this role would be beneficial to have this as well. But I know we have a few witnesses, and if there's any questions, be happy to answer them. Otherwise, I'd like to request a right to close.
All right, members, any questions?
Thank you, Mr. Chairman.
All right, we will proceed to testimony. Chair calls Kathy Hagler, representing yourself. Hello, ma'am. I show you registered as Kathy Hagler. You're representing yourself, and you are here to testify for the bill.
That's correct, Mr.
All right,
Chairman.
you may proceed.
Okay, so Vice Chair Busey has corrected some really bad problems, and I think these are wonderful fixes. If you look in 86.011D, it says that the early voting clerk can return the ballot carrier envelope to the voter for correction, but we stopped that procedure right after the first election where we tried that. Once a ballot carrier envelope is received by the early voting clerk, at this point, we never let it leave their office. So this puts the law back into conformity with what we're doing. If you look at Secretary of State Form 6-14, it says that the early voting clerk can notify the voter of a defect, but the voter cannot cure the defect by mail. They have to actually come into the elections office for anything that can't be cured online, and I think it's ridiculous. We actually had to reject a voter that was notified by the early voting clerk, and they mailed in their correction. House Bill 569 also eradicates the dual dates. Right now, if the early voting clerk notifies the voter of a defect, the voter only has until 7 o'clock on election night to cure the defect. But if the signature verification committee or the early voting ballot board cures a defect, the voter has until the 6th day after the election to cure the defect, which is also pretty ridiculous. They should have the same amount of time to cure their defect regardless of who sent them the notice. And I'm particularly fond of the requirement that poll watchers are entitled to observe activities under D and F. Right now, that's not allowed because poll watchers are not allowed to hang out at the elections office. And there is no notification required for when the elections office is going to provide any kind of notice to the poll watchers who wish to observe these activities. So I am very anxious to see how this is going to be resolved, but I would love the idea that we could have poll watchers there to watch this happening. So I think that HB 569 addresses some really important issues that need to be fixed, and I appreciate Chair Busey for bringing the bill.
Thank you, ma'am. Members, any questions? Thank you, ma'am, very much. Chair calls Catherine Cano, representing herself. Hello, ma'am. I show you registered as Catherine Cano. You are representing yourself, and you are here to testify for the bill.
Yes.
Okay, you may proceed.
Okay, I would like to ditto everything the previous witness
We
just
like
said and
ditto.
add a couple of comments.
Okay.
So I do love this. It does address current inconsistencies in the law, and I'm going to tell you a little fun story. I was talking to my presiding judge yesterday because our ballot board in Tarrant County is currently talking about what procedures we're going to use. And I brought up the difference between the early voting clerk's notification and the ballot board notification, and she was like, "Yeah, we do need to fix this." So this is exactly the fix we were talking about. I'm so happy. One thing I would like to point out, because I'm not sure if this particular thing would be covered by this bill, but but we would very much like to see it covered, is that there is a difference between curable defects in assistant incomplete statements and witness incomplete statements. So on the carrier envelope, that's the bottom part where there's an assistant fills out the information on the left-hand side, and a witness fills out information on the right-hand side. Currently, only the early voting clerk's office can provide notice to the voter that the assistant affidavit is incomplete. The ballot board cannot do that. But the ballot board can notify the voter that the witness statement is incomplete and provide a cure that way. So if a ballot gets transferred to the ballot board that has an incomplete assistant affidavit, there's no easy way for that to get fixed, right? That would just be a cause for rejection. So if we can make it so the ballot board also has that authority, that would be really helpful.
Thank you, ma'am. Members, any questions? Thank you so much for coming forward. Chair calls Kevin Hale with the Libertarian Party of Texas and yourself. Hello, sir. I show you registered as Kevin Hale. You're with the Libertarian Party of Texas and yourself, and you're here testifying for the bill.
That is correct.
Thank you, sir. You may proceed.
Thank you. I am not in the weeds like those ladies, so trust them more than me. As a candidate, I'm on the outside looking in. I am allowed to have somebody in there, but I typically just trust. We like the bill. It empowers voters through fair process, defending the individual voting rights, transparency and accountability in election administration, and of course, a voluntary participation. So we're really happy with the bill and the changes. So thank you very much.
Thank you, sir. Members, any questions? Mr. Raymond?
I should have asked earlier, Chairman, but thank you. So what have you run for?
I have run for Congress 3 times.
Where?
Twice in Congressional District 5.
Where is that?
Dallas and East Texas.
Uh-huh.
And then once in Congressional District 32, which is
where?
literally Dallas and a little bit of Collin and a small piece of Denton.
All right. Thank you.
Thank you.
Members, any other questions? Thank you, sir. Chair calls Catherine. No, that's not Catherine. Right? Okay. Chair calls Laura Rogers with the County and District Clerks Association and yourself. Hello, ma'am. I show you registered as Laura Rogers, and you are representing County and District Clerks Association and yourself, and you are here to testify for the bill.
That's correct.
All right. Welcome back. You may proceed.
This is my last one, so you'll be
All
done
right.
with me. As you said, I'm Laura Rogers. I'm the County and District Clerk in Sherman County, and I'm here to testify on behalf of the County and District Clerks Association in support of this bill. It's a great cleanup bill, especially for us rural counties. Our mail in Stratford, where I live, has to go all the way to Amarillo, which is 90 miles away, to be sorted and shifted and whatever they do. And then 90 miles back to my office to get the corrections and that kind of thing fixed. So whenever you're putting more and more delays on getting these errors fixed, it's just taking longer to get those ballots back. So we really appreciate this cleanup, and we're in all support of it.
Thank you, ma'am. Members, any questions? Thank you for coming forward. Chair calls Ed Johnson with Harris County Ballot Security and yourself. Hello, sir. I show you registered as Ed Johnson. You are here representing Harris County Ballot Security and yourself, and you are here to testify for the bill.
That is correct.
All right. You may proceed.
So, I couldn't pass a chance to be for Representative Busey bill, especially one that helps Republicans. This is great. What a world. So your cleanup here, the biggest problem I always saw in there was a good conservative always likes to save money, and the husband and wife would stick their ballots together in the envelope and both sign the outside of it and send it back. And of course, you can't accept that. This gives them the ability, right when that comes to the mail, to notify those people so they can cancel that ballot and get another one sent to them and get it voted in time. If you wait till the ballot board, time has passed up. So this is a great fix for those problems.
Thank you, sir. Members, are there any questions? Thank you.
Thank you.
Yeah, I'm sure you are tempted. Oh, gosh. Is there anyone else who wishes to testify on for or against HB 569? If not, the chair recognizes Vice Chair Busey to close on the bill.
Thank you, Mr. Chairman. In my 4 terms on this committee, I think every time Ed Johnson has supported one of my bills, it's become law. So if we want to vote it out today, we can do that right now. No, this is an easy cleanup. We've done good bipartisan work, Senator Hughes and I, with almost unanimous support of both chambers over the years. And this is just one more little cleanup to help try to do that. And I hope we can get this passed.
Awesome. Members, any questions?
Thank you.
If there's no objection, the bill will be left pending. Is there objection? Chair hears none, the bill is left pending. Chair lays out House Bill 2773 and recognizes Chairman Leach to explain the bill. The chair offers a committee substitute. Welcome, sir.
Hey, Chairman, thank you. Good afternoon, members. Chairman, Vice Chair Busey, appreciate you allowing me the opportunity to lay out House Bill 2773 to you today, and appreciate the courtesies in delaying it from last week to this week. Members, under current law, election officials are prohibited from altering any statutorily prescribed election procedures. However, there is no meaningful enforcement mechanism or penalty for not complying with this state statute. House Bill 2773 seeks to address this gap by adding penalties and enforcement procedures to the Texas Election Code regarding unlawful altering of election procedures. First, this bill directs the Secretary of State to investigate any alleged violations of the law and to make a determination on whether or not a violation of law occurred. If it's determined that a violation did in fact occur, the Secretary of State would be required to send the local election official notice of the determination along with a demand to cease the violation. If the local election official is still out of compliance within 2 days of receiving notice of that violation, then the Secretary of State is directed to notify the Attorney General and to forward any related documentation to the Attorney General. Second, the bill provides stiff penalties for failing to comply after receiving an official notification from the Secretary of State's office. The Attorney General would be authorized to recover a civil penalty not to exceed $1,000 per day after the 2nd day after receiving notice, and $5,000 per day after the 7th day of the official notice. The bill does specify that any information and documents from the Secretary of State's investigation are confidential, that they're not subject to disclosure unless it's determined that a complaint will not be investigated further or subject to any additional proceedings. The substitute before you today makes several changes to the bill as filed. First, the sub adds that repeated violations of the statute would be considered grounds for removal of an election official other than an elected official. Second, it requires the Secretary of State to produce a monthly report on any violations and to post that report on their website and make it available to the public. The committee sub ensures that the Secretary of State's office could also be held accountable for unlawfully altering any election procedures, as well by allowing a public official, election official, or registered voter to report an alleged violation by the Secretary of State or any personnel working in the Elections Division to send notice to the Secretary. Further, the bill requires, the committee sub requires the Secretary to take corrective action and to provide notice to the reporter with either explanation of what corrective measures were taken. This information must be included in the monthly report that's required by the bill. Finally, members, the sub allows for the complainant to bring an action in a district court for compensatory damages and significant relief and may not assert official immunity. In closing, election officials in Texas are entrusted with implementing our elections and election procedure in the state. However, they're not authorized to make changes to those procedures, nor do I believe they should be. Texans need consistency throughout the state. They need to have trust in our elections, knowing that the law will be followed and that there's a process for when state law might be ignored by an election official. With that, Mr. Chairman, I'm happy to answer any questions and would request my right to close.
Thank you, Chairman. Members, any questions? Mr. Raymond?
No, go ahead.
Mr. Raymond, you're up.
Go ahead. Okay.
All right,
yes.
Ms. Morales-Shaw.
Yes, thank you, Chairman, and thank you, Rep. Raymond. Yes, Rep. Leach, I'm just trying to, the wording in this bill is abstract to me, and I'm trying to understand what problem you're trying, is there a specific problem that the bill is addressing?
You're going to hear some good testimony today from some of the witnesses who are here that I think can go into more detail than I can about what specific allegations and problems this bill has been drafted to address. In my closing, or in the closing of my opening, I should say, as I made clear, I simply believe that at the end of the day, when we say this is the election law of the state, and we entrust our election officials to carry that out, that any diversion from those procedures, that there should be given an opportunity to correct it. But if they're not, and if they're willingly and intentionally and knowingly diverting from those election procedures, then I believe there need to be penalties and reports made on that. The public needs to know about it, and the Secretary of State should be able to step in. So that's what this is meant to do. In terms of specifics, I think you're going to hear some of that from the witnesses who are here today.
So this bill addresses only things that are written to make sure they're upholding it. So if I give out a I voted sticker, that's nowhere written anywhere, and that could be considered a deviation. That's just a simple example.
That would not be, it's not my intent to prevent anyone from giving out an I voted sticker. That's not the intent of the bill. And if we need to, I will readily admit to you, Representative Morales-Shaw, and to the committee, the chairman and I and vice chair, we've briefly discussed this, that there needs to be additional work done on the language of the bill. I know there's a Senate bill that's kind of moving through the process as well. There's a lot of conversations going on with the Secretary of State's office, the Attorney General's office, our Senate counterparts. And so I will readily admit to you that this language does in fact need to be tightened while still preserving the intent of the bill. And that's one of the reasons I look forward to the hearing today, is so that we could determine exactly what those changes are.
Thank you.
Thank you.
Mr. Raymond.
Thank you, Chairman. Chairman, if there are this passes, right? And we have a situation where there are penalties imposed, or fees, fines, civil penalty. So how can they, I guess it doesn't really speak to this. The person who is fined, let's call it that, can they pay with campaign funds? Do they pay if they're, can they pay with, county funds? I mean, I don't know. Bitcoin? I mean, no, I'm serious. How do we speak to that at all, or does some other part of the code?
The bill doesn't specifically address that. I too have had that question about where those funds. I think they're at the end of the day, it's going to be a personal liability on that official.
Yeah, but can somebody donate to that person and say, hey, here, let me help you out?
It's a great question. I actually was thinking about that earlier as I was preparing for this. The goal here is to deter deviation from state mandated election procedures. Right. And so to me, if we're allowing funds to be set up to send money in, to defend against these, to pay fines, to me that presents as a disincentive from following the bill.
Yeah.
There needs to be some, for lack of a better word, skin in the game. That's probably not the right.
I'm just wondering if what you're trying to do is, get someone to think real hard about. You've been warned. You've been told, hey, you got to do this right, and they continue to do it wrong. They don't have to worry about. Like you got a fat campaign fund, so you pay for.
That's not accurate. But, I will disagree with you there.
That's if you had a fat campaign fund.
Well, yeah. So I think that my gut tells me, I'm happy to talk with you about this, but my gut tells me we want to. The goal of the bill, the mission of the bill, is to create a incentive personally for that individual to make sure to do everything that they can to make sure that they're following election laws of the state, and to face the very real possibility that if they don't, it's going to mean something personally to them.
Yeah, and the second part of I guess your committee sub where if it goes far enough, then they can sue you to get compensatory damages or whatever what'd you say? The second part where you said they could get damages.
Yeah, well, they can get. I don't know exactly what it is.
Well, the damages. Let's just say beyond the fine.
Right. It would allow an action to be brought in district court, so that you wouldn't have the Secretary of State or the Attorney General imposing. It would allow an action to be brought for compensatory damages.
Yeah, and so whether you speak to that as well, as far as how they would pay that should they lose. Something to think about.
Sure. It's a good point. I am thinking about it. My instant response, without knowing exactly what the bill provides for, I think we need to clarify that. It would be my goal that funds not be able to be donated to someone who is knowingly violating state law. That to me would kind of gut the purpose. of the
Yeah,
statute.
because I mean, what'll happen is, you get, either George Soros or.
Both sides. Both
Exactly,
sides.
yeah, I don't want to
Yeah.
say the other side because I think Elon Musk is great. I love him. I think he's the best. I think he's great. I love him. Smart guy, really smart. But you know what I'm saying?
You sure? I
Yeah,
do.
all right.
I do.
Members, any other questions or impersonations?
Yes.
Ms. Morales-Shaw.
You mentioned Rep. Leach knowing. Does this bill have a knowing component, a mens rea?
No. I don't believe it does.
Okay. I didn't see it in the
No.
language, so.
No, I mean, but look, clearly, because we're involving different levels here, it's a good question. We're involving different levels here. The Secretary of State's office is involved, the Attorney General's office is gonna be involved, we have election officials involved. Clearly, it would be my hope, and if we need to tighten the language, we can, that simple mistakes or oversights, I mean, we're human. These mistakes are made. This is when someone is deliberately, or maybe carelessly or recklessly carrying out their job. So, I think if you want to put let's hear the witness testimony. I'm looking forward to hearing some of the witness testimony, and if we need to put a mens rea component into the bill, then I'd be happy to talk.
Okay, and there is opportunity to cure, right? Once they get notice, there's an opportunity,
Yes.
a reasonable.
Yeah, now it's a short opportunity.
Yes,
Because,
I saw
we're in the middle of an election, so it's quick, but there is an opportunity to cure.
Okay, thank you.
Members, any other questions? Thank you, Chairman Leach. We'll
Thank you.
recognize your right to close.
Thank you,
We'll go to testimony. Chair calls Daniel Hunt, SREC Committee Man, SD3 and self. Chair calls Kathy Hagler, representing herself. Hello, ma'am. I show you registered as Kathy Hagler. You're representing yourself, and you are neutral on the bill.
That's correct, Mr. Chairman.
All right, welcome back. You may proceed.
Okay, so I love what the bill is trying to do. I absolutely love it. But as I've told y'all before, I've worked with an election integrity organization. We take phone calls from voters, from election workers, from poll watchers, all over the state, any party. We're nonpartisan. We field questions. And I have to tell you, we get a lot of questions that are frivolous. They're just mad about what somebody said to them in the polling place. We get people who say, "Did you know that they've got live internet going on in the polling place?" Yes, we did. That's in the law. Well, I had to wait in a curbside line for 4 cars, and it took me almost 2 hours before I got to vote. There's going to be right now. This bill allows any voter in the entire state of Texas to call the Secretary of State's office and make any kind of complaint. They don't have to have any evidence. And it doesn't say they have to say what's been violated, what law has been violated. My concern, coming from a group that we take all of those calls freely, that's what we do as a service. I'll let Secretary of State speak for themselves, but I think there's going to be a problem with too many people just flooding their network. And my idea of a solution would be that we would have a filter at a county level. So if you had an issue going on in your county, you would need to have 2 different people that you could talk to that had different responsibilities. My suggestion would be your EA or county clerk and your county chair. So if the county chair is messing up, you complain to the EA. If the EA is messing up, you can complain to your county chair and let that person tell you, you don't have an issue, it's not a problem, or, hey, we've got something serious we need to take to Secretary of State, and then go ahead and call a hotline number. I just don't think it's wise to just put everybody to the Secretary of State and ask them to stop, drop, and roll for thousands of calls, respond within 48 hours, and I just think that's going to be too much for them. So I'd like to see us put some kind of intermediate filter, and like I say, I'll let them speak for themselves, but I think they're going to have to hire a lot of people for early voting and election day to handle this. And the PS is, I would love to see personal liability rather than taxpayer dollars paying for it.
Thank you, ma'am. Members, any questions? Mr. Raymond?
Thank you, Chairman. So do you, and you may have mentioned this, but is this sort of based on your experience where you see people that you feel like are going to, you said flood, so you think that they could, it's just, are you seeing people complain, and what do
Yes,
you
sir.
think
I
in a
mean,
frivolous manner? at
On
this point,
election
or-
day, we probably get, I'm going to say, probably over 500 phone calls just in my organization. which there's many in my party, and which there's several parties and a lot of different people who take these kind of phone calls. And if the word gets out, you can just go call the big dog. You don't even have to mess with all these other people. I'm just afraid I don't mind being put out of business, but we're going to be putting a lot on SOS. So I'm concerned that there's no filter, that anyone can call. They could have 10,000 people calling them in 2 weeks. How can they respond to that in 48 hours?
We'll ask the chairman if he's kind of thought about that part of it, because it's a fair point with 254 counties, right?
Yes, sir.
Yeah, all right.
Thank you.
Members, any other questions? Thank you, ma'am, for coming forward. Chair calls Veronica Warms with the Texas Civil Rights Project. Welcome back, ma'am. We show you registered as Veronica Warms. You are here representing Texas Civil Rights Project, and you are here to testify against the bill.
Yes, sir.
Okay, you may proceed.
Thank you so much. This bill would allow the Secretary of State to unilaterally determine that an election official created, altered, modified, waived, or suspended any election practice, standard, procedure, mandated by law, or rule in a manner not expressly authorized. After that determination, the Secretary has to refer that matter to the AG for potential action to recover civil penalties. We are concerned that this bill doesn't set any standards for how the Secretary makes that determination, while it simultaneously doesn't afford the Secretary any discretion in whether or not to refer that matter to the AG. We are already hemorrhaging election workers and election officials, and imposing personal liability on these folks will only increase that problem. We are also highly concerned about the potential for this bill to undermine the legally protected right of voters with disabilities to receive reasonable accommodations when voting. The Election Code states that a provision of this code may not be interpreted to prohibit or limit the right of a qualified individual with a disability from requesting a reasonable accommodation or modification to any election standard, practice, or procedure mandated by law or rule. And the Secretary's Handbook for Election Judges and Clerks states that both election judges and early voting clerks have the authority to grant a request for a reasonable accommodation at their discretion. But we're concerned that HB 2773 could cause confusion for election judges and early voting clerks who may err on the side of caution by denying requested reasonable accommodations for fear of running afoul of these civil penalties. If HB 2773 passes as written, the Secretary is on the one hand telling election judges and early voting clerks that they have the sole discretion to grant those accommodations, while on the other hand, it can second-guess that decision and unilaterally refer the matter to the AG's office for potential imposition of thousands of dollars of civil penalties. It doesn't take a great leap to see why that kind of setup would cause a chilling effect on granting these requests for reasonable accommodations and curtail the rights of disabled voters in Texas. So for those reasons, we ask you not to report this bill favorably. Thank you.
Thank you, ma'am, very much. Members, any questions? Mr. Raymond?
I think you're following this stuff closely, so you must have some sense what the chairman's trying to do with this bill, right?
Yes, I understand what the chairman seems to be driving at with the bill.
And so would you agree that what he's striving to do is a good thing? I mean, if somebody's not, believe it or not, there are going to be some officials out there that will not follow the rules or do things their way. Hey, this is my county. I know how things are run here, you know, that kind of stuff. I mean, or somebody's been doing something, you know, election-wise for a long time, and we pass some laws, and then they tell them, oh, no, that's not the way it is. And, oh, no, I've been doing it like this for a lot. We're going to do it this way. So, I mean, this is a big state with a lot of counties, a lot of elections all over the place. And so I know I've seen it through the years where someone is, you know, kind of doing the way they want to do it, not necessarily the way we, as a legislature, decide the law will be and the process will be, et cetera. So where are you from?
I mean, I'm a bit of a nomad, Representative Raymond, but I've been in Austin for over 10 years.
10 years, okay. So you followed elections, the election process?
Yes, sir, I'm a voting rights attorney.
Okay, perfect. Well, then you probably have seen a lot. So do you see where, you know, it's never easy to thread the needle, but I think that's what he's trying to do here, is how do we make sure that people who are running these elections or who are involved in you know, these election processes, that they, you know, follow the law, basically, right?
So Representative Raymond, I understand what you're saying. I think that the place for that kind of dispute and interpreting the law is a court of law, actually, and setting up this extrajudicial process where an unelected political appointee is going through and saying, oh, from our interpretation, you are violating election law. And setting up that extrajudicial process is a problem for democracy. I think that we should have, that those types of disputes and decisions on whether an election law has actually been violated should be sorted out in court and not by the Secretary of State's office.
Well, I can speak to a personal experience again. Early on, when I got involved in politics and in elections, where I had asked for the Secretary of State's office to be there because I anticipated they were going to try to steal the election. I don't know how else to say it. That's the way it was. I grew up in Duval County. I don't know if you ever heard of it. And so, sure enough, they did. They tried to do that. But we had two folks there from the Secretary of State's office. And although I was a very young guy and, you know, wasn't an attorney or anything, but I could read the law, the rules. And I said, y'all aren't following them. You're not doing this right, to the judge, because I was a poll watcher. And the Secretary of State people looked at it and said, no, he's right. You're not supposed to do that. So the election judge said, well, call your main office up in Austin and ask them up here, right? They called. They said, no, they shouldn't do it. And the election judge said, well, I'm going to do it anyway, right? Because the only thing you could do at that point was try to go to court. And so even though it was so obvious that they were not doing it right, you know, but it wasn't right that they had to go. The only way you could stop what was going on was that you had to wait till after the election at this point, you know? It just wasn't right. Anyway, I appreciate where you're coming from. I really do. But I feel like we have to keep trying to figure out how to do it right, get it closer to doing it right.
So I appreciate where you're coming from as well, Representative Raymond. I just think that, and to be clear, I don't have a problem with the Secretary of State informing a county if they think that they violated election law. I do have a problem with imposing civil personal liability on election workers and election officials and setting up an extrajudicial process to do that on a very short turnaround. I think that's potentially problematic.
Well, like in the example that I experienced, I mean, I promise you, if that guy had figured that he might be on the hook for something, they might have listened to the Secretary of State in that moment, you know? I don't know.
Members, any other questions? Thank you, ma'am, very much for being here. Chair calls Susan Valiant, representing herself, SREC, hold on one second.
He's going to get it one of these days.
All right, I'm going to try this one more time.
Okay.
You are registered as Susan Valiant. You are representing yourself, and you are here to testify for the bill.
Yes, sir.
All right, you may
and I'm
proceed.
SREC SD10 and Texas First. Should be on there as well.
So just to make sure we're clear, you also want to register to represent SREC SD10 Texas First Elections Group?
Correct.
All right. We're going to get this right. Come up one more time.
This is the last time, so
we'll get it right.
You're good after this.
And you're testifying for the bill?
I'm testifying, yes, in favor of the bill.
Okay.
Yes, Chairman.
Thank you, ma'am.
Thank you. One of the things that I want to address is that this also doesn't address the Secretary of State in their overreach of the law as well. That was indicative of the Secretary of State's Advisory 2024-20, whenever they made the decision to redact the information off of the ballots in the and they went retroactive back to at least 2022 before we started doing precinct voting. Now that it's redacted, that's a temporary fix. There's no permanent. They have not given us a permanent solution other than just keeping it redacted. But that's also violating the auditing, which is also in Election Code 122.001, and it's also precedent. In Sewell versus Chambers, auditing actually overrides the secrecy of the ballot. So by us by the Secretary of State redacting the information instead of getting rid of the countywide voting or eliminating the countywide voting, which is 7% of the issue of, because the rest, the 90% of the other voters that vote within their residency, you can't identify them. It's only 7% that you can actually identify, which happens to be the most, because I identified 117,000 people in Texas. Their ballots I could identify. Another issue is with election officials. We were talking about earlier combining precincts. Well, I learned after talking to some of the staff members of the representatives that the representatives go by the census count, where the election officials in the counties go by the current population. So there's a difference right there, because if we went by the census count, Tarrant County wouldn't have to do that. They would be able to combine, whereas the election officials are actually going by the current population, which we are over 1.2 million now. So now they're not going to let us combine. Another issue was the Secretary of State's on the limited term driver's license. It's a non-citizen. First reported that was going to be acceptable ID for voting, and then had to turn around and make a waiver to make it that they had to also produce naturalized citizenship paperwork for that. And then another one is, according to Election Code 52.062, all ballots are supposed to be consecutively numbered, starting with the number 1. And the Secretary of State did upon themselves to waive that and make it to where the machines can actually do the counting of the ballots. So those are kind of some examples that I had. That's why I'm in favor of this bill, but I wanted to also think that we need to consider adding the Secretary of State as being one of those that needs to be accountable to the law.
Thank you, ma'am. Members, any
Thank you.
questions?
Chairman,
Ms. Morales-Shaw?
thank you for your testimony. I was a little confused because you're for the bill, but you were given examples of ambiguities that I think you're saying election workers and public officials wouldn't know what to do because there's ambiguity.
Correct.
Okay. I
That's-
just wanted to make sure I understood what you
Yes, but taking it upon themselves to do,
their
take
interpretation.
their interpretation of it.
So
Yes.
you're saying if the law isn't clear, we maybe should consider not holding them accountable until the law is clear?
Well, there is a stipulation in there which they have a way of correcting anything. So, I would rather have that avenue and correct, whatever issue it is. Unless like the countywide voting thing, it's not ever gonna, evidently that's gonna be a big issue. Because that's gonna still continue, even if you get rid of the small precincts
Right.
and combining them, you're still gonna have people that vote outside of that precinct, and you're gonna be able to identify them unless you redact the information. And if you redact the information, that's actually violating another law because we can't audit at that point. And we have to be able to audit, and that actually auditing actually supersedes the secrecy, just because of the
Okay.
Sewell versus Chambers.
Thank you. Well, hopefully the Secretary of State will give us some more clarity on that.
Okay.
But thank you for your.
Thank you.
And we'll call them up towards the end as a resource witness. Any other questions, members? Chair calls Ken Moore, representing himself. Welcome back, sir. I show you registered as Ken Moore. You're representing yourself, and you're here to testify for the bill.
Yes, sir.
Okay, you may proceed.
And you'll notice that I always represent myself to avoid the complications of where I can draw the line. Anyway.
I appreciate that.
I'm not sure where to begin. There was a former colleague that used to be on this committee, Mike Schofield. And I remember there was a bill that came up one time, I think 2 sessions ago. And I think it had to do with curing signature issues. And we had some people come in who were, the Disabled Americans Group, and talking about there's some people who just cannot sign their name twice the same way. And of course, what they were after was to get rid of the signature, and Chairman Kane wasn't going to have that, but he did acknowledge you had a point. And he said, come by my office to see what we can work out. And Mike Schofield made this point, that this is how you do legislation. You take the facts available, and you try to craft a bill, and then you invite people of different groups, Republicans, Democrats, Libertarians, and people from different advocacy groups, and get their input. And you take that and you find to come up with something that is workable. You don't let local officials go off on their own and invent the rules. Now, you've heard horror stories from Harris County. You had the drive-through voting that they came up with, and complained about how you want to take it away from us. You never had it. The law is very clear about where what kind of a polling place you have to have, how it's supposed to be structured. There was another that came up about sending constables out to pick up the voting materials from the polling places. The law is very clear. The election judge drops those off. And so when the drive-through voting, you had wind blowing through there, you had rain blowing through there, you had papers flying everywhere, you had people in cars together, no privacy. When it came to picking up the materials, you didn't have enough constables. Some election judges were busy waiting until midnight to have this stuff picked up. And it created a lot of chaos. And that's why you do this very process right here of sitting down and carefully crafting legislation and looking at issues and trying to find ways around them. The civil lawsuits, is that a warning or is that my time?
That is a warning. You have
That is a warning.
15 seconds to wrap up,
15
sir.
seconds,
Yes,
okay.
sir.
I put my SRC hat on for just a second, and thank you to Dr. Presley for pointing out that having civil lawsuits as an option is part of our platform. It's like 221L in the Republican platform, if that carries any weight with anybody.
Thank you, sir. Members, Mr. Raymond.
Thank you, Chairman. You're Republican, right?
Yes, sir.
Yeah, all right. I'm a Democrat, but I'm so glad to know we agree on something, man. It was your testimony. You were talking about the drive-through voting, during the pandemic and all that, right?
Mm-hmm.
Right. Because I'm absolutely convinced you're right, that if we had not had that, okay, Biden would have carried Texas, okay?
I'm not sure what to do with that, but
You're not supposed to do anything with it.
I'll take the pat on the head anyway.
Members, any other questions or comedy routines? Thank you, sir, for coming up.
Yes, sir.
Chair calls Lucilia Siri, representing yourself. Hello, ma'am. I show you registered as Lucilia Siri. You're representing yourself, and you are here to testify for the bill.
Yes, sir, I
Okay,
am.
you may proceed.
Yes. So adding up to what Susan was saying, and I don't think that she means about the ambiguity when it comes. So I'm for this bill. I think we need stronger penalties when it comes for election integrity. There's fraud both ways. I'm not saying it's everywhere, but there is, and both ways. And I do think that some of that is caused by the Secretary of State's advisories. And it's not about creating ambiguity, it's going against the law. Their advisories. We had issues in Tarrant County. I'm a Republican precinct chair, we're all about election integrity, and a big issue was that the numbering in our ballot got removed. Susan referenced 520062, that is the one that asks you to have number in the ballot. But you also have 62009 that requires you to shuffle the ballots before the voters grab them in an order that the number is not in order. Ergo, the ballots need to be pre-numbered. Then when it came to, yes, the limited liability license, last year, that advisory saying that pretty much election clerks needed to allow non-citizens to vote. But then, because people saw that and they rage against that, they said advisory 2024-30 pretty much said that you needed to remind a voter with a limited a limited term driver's license, those licenses are given to non-citizens. They're like, okay, maybe they become citizens, they didn't have time to update their driver's license. But you need to ask them the questions and remind them that it's illegal to vote in Texas if you're not a citizen. But at the end of the day, based on this advisory, if the voter persisted to vote, the clerk was to allow the voter to vote with a regular ballot. When we do have provisional ballots in place, that should have been the correct advisory. So if people would have not caught this up, and a clerk allowed an illegal to vote, that clerk would have been liable because this bill has no penalty for the Secretary of State. I think that the Secretary of State needs to be more thorough with the advisories they do. Susan mentioned several, and those are just a few. 2020, 2024, there were like a lot of advisories. So yeah, I like the bill. I think we need to add the Secretary of State, and I'm okay with this get sorted by the Secretary of State. We don't need to go to courts to solve this, but of course, the voter attorney wants us to go to court to sort this out, of course, but no. So yeah, that's what I have.
Thank you, ma'am, very much. Members, any questions?
I just have
Ms.
a clarifying
Morales-Shaw.
question. Thank you, Chairman. So it sounds like your opinion, I think, and correct me if I'm wrong, is that if someone makes an error, but it's based on an advisory opinion that contradicts the law, that they shouldn't be held liable because it's unclear.
No, my opinion is that the Secretary of State should be punished for doing wrong advisories that go against the law. And yes, the person that follows that wrong, that creates an ambiguity. But who creates the ambiguity? The Secretary of State. The Secretary of State should know the law and should not advise against the law. And if they do, they should have some penalty under this bill, yes.
Okay, thank you.
Members, any other questions? Thank you, ma'am, very much for
Thank you.
coming forward. Chair recognizes Debbie Lindstrom, representing herself. Hello, ma'am. I show you registered as Debbie Lindstrom. You're representing yourself, and you are here to testify for the bill.
And Citizens Defending Freedom.
So you are Debbie Lindstrom. You're representing yourself and Citizens Defending Freedom?
Yes, sir.
And you're representing you're here to testify for the bill. Hold on one moment.
Yes,
We're going to
sir.
make a slight correction to the registration. Okay, ma'am, you may proceed.
Chairman Shaheen and distinguished committee members, thank you for the opportunity to speak today. I'm Debbie Lindstrom, Texas Elections Director for Citizens Defending Freedom, and I strongly support HB 2773. The Texas Constitution explicitly mandates in Article 6 that the legislature make regulations necessary to detect and punish fraud and preserve the purity of the ballot box. It further requires that suffrage shall be protected by laws prohibiting all undue influence in election from power. Punishing election crimes is not merely a legislative option, but a constitutional obligation. Yet currently, Section 276.019 prohibits unlawful altering of election procedures without any enforcement mechanisms, rendering it effectively toothless. CDF has documented numerous instances where election officials have altered or suspended election code across Texas. I'm submitting a 50-page report detailing citizen testimony regarding multiple violations, and other witnesses are already testifying about specific examples. Despite the Secretary of State identifying violations, the lack of meaningful consequences has allowed violations to continue and even escalate over multiple election cycles, undermining public confidence in our electoral system. This bill creates an enforcement structure with a notification process giving officials time to correct issues, graduated penalties that focus only on willful violations, and transparency provisions ensuring fair application, and then a clear accountability for all parties from local election officials to the Secretary of State. Importantly, this approach is actually less severe than potential alternatives, offering officials clear guidance before consequences occur. It replaces costly litigation with an efficient administrative process. Some might worry, that, and we've already heard this, that it might discourage election workers. This fundamentally misunderstands both the bill and those who serve. HB 2773 focuses exclusively on willful violations, not good faith mistakes. The vast majority of election workers are dedicated public servants who aim to follow the law precisely. The notification requirement ensures no one faces penalties without first having the opportunity to correct the issues. I just want to say that election integrity transcends partisanship and applies equally to all, and without meaningful consequences, our current system accomplishes detection but fails on punishment. I strongly urge this committee to support HB 2773 to strengthen public trust in Texas elections and fulfill your constitutional duty to protect our electoral system.